Yeah, sound test. Can you...
Oh, yeah. This course is way too long.
No, I have an essential course. Something on it.
I'm good. No, I can. This thing that I had is on.
What did you think about it? What did you think about We're going to take everybody to dinner. When I say the bus is going back. Just talk. We always catch up. It's always fun talking to each other. And vetting somebody's out. And what do you think that shift? What do you think that shift? What do you think?
No, you got to put it on this mic.
What's that for?
For you to place it like somewhere where people can hear it.
Let's see, where you probably need it more, something like a judge bench or so?
We'll talk or maybe in the middle.
I could put it right there where the court recorder's desk is, if that makes sense.
Okay.
Like right in the middle, because I don't know where y'all going to be.
What about the top of that podium?
We could. So. So, the additional mic, I'm just going to put it right there by the podium or something. What's that?
Yeah. Sure.
All rise. Superior Court of Lane County is now in session. Honorable Timothy Hall.
All right, good morning, everybody. You can be seated.
Good morning, Your Honor.
All right, we are on the state of Georgia versus Travis McMichael, Greg McMichael, and William Roddy Bryan, case number CR 2004-33. The matter was noticed for a motion for new trial. We had a brief telephone conference on Monday. It's my understanding that we are ready to proceed. But that said, let me go ahead and get official announcements from the state.
The state is ready, Your Honor.
We're ready on behalf of Travis McMichael.
Ready on behalf of Greg McMichael.
Same with Mr. Bryan.
All right. The matters before the court then are motions for new trial filed by all three defendants. There may be some preliminary matters we need to address, so let's go ahead and see what's there. So, can we from the state court then?
Not at this time, Your Honor.
On behalf of Travis McMichael.
Your Honor, based on, I don't move real quickly. Based on our conversation, I think my understanding is that we need to do something with regard to a proffer and a juror testimony, and there are issues there that I suppose we need to take up before we get into anything else.
Addressing the subpoenas out for jurors in the case.
Well, and the state is taking the position that we need to have some preliminary consideration by the court as to whether that testimony will be permitted. And that's, it seems to me that needs to be early in our activities today.
Mr. Check.
Your Honor, we joined with Travis McMichael's amendment to the trial, so same issues, yes, Your Honor.
All right, Mr. Justice.
I don't want to be left out, so we'll join next as well.
All right, so why don't we go ahead and address what we have. When I say what we have, what I understand the issue to be before the court. A number of subpoenas that went out for jurors to testify at matters that are in the, I would say, the joint motion for new trial. The lawyers can please check the gallery to ensure that there are no witnesses in the gallery who they would expect to call, and then continue to check the gallery to ensure that there are no witnesses present.
I don't know whether we have two jurors who have been subpoenaed and are here. One who's been very reluctant to come, and I told her that I would put her on a 1-hour notice rather than make it's an unusual inconvenience for her. So we'll call her on an hour notice. And if juror 79 and juror 380 are here.
Perhaps, Your Honor, if we could just announce, is anybody here?
Understands they are under subpoena and being asked to testify in today's proceeding. Please take a step outside and wait there until you are called.
Your Honor, can we invoke an exception for the investigator of the case to self-preparation of the trial?
As the state often does.
Mr. Wilson is our investigator, and he will be testifying, and he'll be testifying early on. But typically, investigating permission.
Let's do this. During this preliminary portion, since we are addressing witnesses' testimony, I'm going to ask that he step outside. Let's take this matter up after the preliminary matters have been addressed.
He will be the first witness on the issue that we're addressing, but I don't even know if the court wants to hear from witnesses yet. So, let's go ahead.
Any witnesses?
Thank you, Your Honor. Your Honor, in this particular case, Travis McMichael and Greg McMichael filed their amended motion. They had previously filed a preliminary motion for new trial back in May, and Mr. Bryan had filed his
motion for new trial, his amended motion for new trial, back in May of 2024. At that time, they brought up the issue to the state and this court that their investigator, Lee Wilson, had attempted to approach all 12 jurors in this case to interview them. 9 refused, 3 agreed, and spoke with Mr. Wilson. The state's, of course, first concern with that is that in approaching these 3 jurors, Mr. Wilson lied to them. He said he was there to interview them to find out what the trial teams had done wrong or could do better in the future. He also told them that it was a confidential interview. He recorded them without informing them, which is legal in the state of Georgia. But he then proceeded to ask them a series of questions designed not to find out what the trial teams had actually done, but to procure evidence in a state's position in a legal attempt to violate Rule 606 and impeach this verdict. So the state has a deep concern about how these interviews were conducted and how this testimony was elicited. And the basis for our objection is actually the United States Supreme Court. The United States Supreme Court has basically held that the substance of Rule 606, which has not changed since 1975 when it was enacted, with one exception in 2006 where it modified permitting evidence for the clerical mistake on the verdict form. Our Rule 606, which was enacted in our new evidence code in 2013, is identical to that particular 2006 Rule 606 federally. But in 2017, in Pena-Rodriguez versus Colorado, the United States Supreme Court held that Rule 606 promotes full and vigorous discussion by the jurors while deliberating because it provides jurors with considerable assurance that after being discharged, they will not be summoned to recount their deliberations and they will not be otherwise harassed or annoyed by litigants seeking to challenge the verdict. Rule 606 gives stability and finality to verdicts. And the Supreme Court of the United States in 2017 was relying on their own opinion in the Tanner case, Tanner. And the Supreme Court echoed the concerns that if attorneys could use juror testimony to attack verdicts, jurors would be harassed and beset by defeated parties, thus destroying all frankness and freedom of discussion and conference in deliberations in the jury room. The Supreme Court of the United States was concerned, moreover, that attempts to impeach a verdict would disrupt the finality of the process and undermine both jurors' willingness to return an unpopular verdict and the community's trust in the system that relies on the decisions of laypeople who are our jurors. The United States Supreme Court did actually go on to determine and elucidate that there are existing significant safeguards for a defendant's right to an impartial and competent jury beyond any sort of post-trial juror testimony. They noted that at the outset of the trial process, there's voir dire, which provides an opportunity for the court and counsel to examine the members for their impartiality and any biases. As the court is aware, jury selection in this case was longer than the state presentation of the evidence and the defendant's presentation of their evidence. We did a thorough job with voir dire, doing individual sequestered voir dire, and that is one of the safeguards. The Supreme Court of the United States noticed that as the trial proceeds, the court, counsel, and court personnel also have an opportunity to learn of any juror misconduct. That is because bailiffs are available, and they are allowed to note if they witness any juror misconduct. And before the verdict, jurors themselves can report misconduct to the court. And as this court is well aware, this court instructed the jurors, both in the morning and every evening, that they were not to discuss this case with anyone, not even amongst themselves, and they were to report back to this court via the bailiffs or the sheriff's department any irregularity, any outside influences, anyone who attempted to approach them, and this court vigorously instructed them on this. The Supreme Court of the United States held that these procedures do not undermine the stability of a verdict once rendered, and even after the trial, evidence of misconduct other than juror testimony can be used to attempt to impeach the verdict. I want to note here, other than juror testimony, extrinsic evidence must be what is presented. I provided the court and defense counsel with 2 cases from the 11th Circuit, United States versus Cuthel, C-U-T-H-E-L. And that went over the court's duty to investigate. And that only arises when the party alleging misconduct makes an adequate showing of extrinsic influence to overcome the presumption of jury impartiality. Actually quoting to United States versus Sun Mun Yoon, and that's that 1983 case where they were accused of tax evasion, that a trial court is required to hold a post-trial hearing only when reasonable grounds for investigation exist, when there is clear, strong, substantial, and incontrovertible evidence. And the state's position is that we do not have that here. In other words, a specific non-speculative impropriety has occurred which could have prejudiced the trial of the defendants. That is what they're required to show, non-speculative impropriety. A hearing is not held to afford a convicted defendant the opportunity to conduct a fishing expedition. That is right from the United States Supreme Court in the 1983 decision. Of course, relying on our Rule 606, the defense attorneys did provide this court and myself with the transcripts of the 3 jurors' statements. Everything within those statements, they do not rise to the level that the Supreme Court of the United States requires and the 11th Circuit requires, which is specificity from an external source other than going back and interviewing jurors 6 or 7 months after they have rendered a verdict. And with 606, we have 3 prongs. One does not apply here, and that is filling out the verdict form incorrectly. We have the first prong, which is when a juror seeks out extraneous prejudicial information. As you'll recall from one of the cases, they had a juror, it was a habeas case out of our Supreme Court here in Georgia, who actually did a test drive to go ahead and determine whether the defendant could have made it to the crime scene on time. Of course, that is a juror seeking extraneous prejudicial information. The other example, which is the Part B under 606, the second prong, is if a juror has someone who tries to bribe them or tries to threaten them. It's an external pressure on that juror, not something made up in the juror's head. Okay? And I would analogize that to defendants who are being questioned by the police who think, well, I thought they were threatening me or I thought there was hope of benefit, but it was all made up in their head. The police did absolutely nothing to encourage that. In this particular instance, there's absolutely nothing where there has been shown that external influences were brought to bear inappropriately on any of these jurors. So the state's position is that we're objecting under Rule 606 and under the cases I've cited because nothing that they have provided to us so far from the jurors' own words rise to this level. And there's been absolutely nothing provided to the state that they're going to provide extraneous testimony through a witness or documents or anything else that these jurors were inappropriately influenced or pursued extraneous information or that extraneous information was given to them. Thank you, Judge.
Mr. Johnson.
Yes, Your Honor. A note first, with respect to the, excuse me, I'll get to this first. Ms. Donkowski's recitations of federal cases does not take into consideration the decision in Harris versus State, 2023 decision. I thought I had it right there. I'll bring it later to the court's attention, but in which, among other things, the Supreme Court of Georgia noted that there are differences in the application of Rule 606 as applied to state courts, or state application of it as applied to the federal application of it. In fact, jurors are from time to time subpoenaed to testify regarding exceptions under the rule. As stated in Official Code of Georgia, Section 24.606B. There is a prohibition in the first part of that, which is absolutely a prohibition against attempting to impeach a verdict, which the court has received from us a notice of our intent that included exhibits from the recorded interviews of the 3 jurors who did speak with us. And note, it's a bit of an overstatement to say all 12 of them or 9 of them refused to talk to us. A few did, and some were just not available. We couldn't find them. But 3 did talk with us. And we submit, and we have submitted to the court, which in a somewhat awkward situation where our understanding was that some things that we submitted to the court were not to be filed with the clerk of court. And
I need to make sure I'm clear with that. That was never an instruction from this court.
Well,
you can debate however you want.
Well, I wanted to read the court's order, Your Honor.
I want to make very clear on the record that at no time during these proceedings, and I think the history of this proceeding is very clear, has this court ever instructed anyone not to file something or do anything that would require a sealing or other action by the court. I understand that notice may have been misread, but that's not a concern of the court. I understand the state was served with everything, the court received everything, so I don't intend to debate it. But I just want to make sure that we're clear on the record that this court has never instructed anyone not to file something.
If I might address the court with respect to the language of the court's order.
You don't need to. I'm telling you, that court order was never intended to tell anyone not to file something.
Well, we have submitted to the judge, to Your Honor, and to opposing counsel and to co-counsel all of the material that we're addressing. We prepared and submitted to all parties the notice of intent to present juror testimony. Attached to that notice were exhibits that described, in part, the testimony. I'll call it a pre-proffer. We wanted to alert the court and alert counsel what it is that we are about here and what it is that we are attempting to present to the court. I misread perhaps the court's order as saying that we should submit those things to the court, to the judge, and to counsel, but not file it with the clerk, which what I did was file the notice without the exhibits, and I'll cure that today by filing the exhibits put them on the record. And I understood it to be a matter of this court's concern over the anonymity and privacy of these jurors. The court went to great lengths to preserve their anonymity and to preserve their privacy, and it is very important that they be protected in that way because this is a high-profile case. There were demonstrators. There were reasons to protect their anonymity. We read the court's order as saying that, and in fact, I addressed the court in correspondence asking for direction on that. I addressed the court in May. I addressed the court in September twice, and within our notice asking the court to direct us as to how do we go about preserving the anonymity of the jurors. Seems to me that it was a very important factor to this court, and we did not want to run afoul of the court's order. Had we filed the exhibits, then we would have been disclosing the identity of the jurors, and that's the reason we sought direction. Let me get some water. I had an accident, Your Honor, in September that for the time being limits my mobility, so I'm having to use a walker and a cane. And I get very dry mouth. Addressing Ms. Donikowski's argument, State v. Harris notes, and that's the 2022 iteration, and then again in 2023, our Supreme Court has held that the application of 606 is different under the state rule as opposed to the federal rule. And Ms. Donikowski has cited to the court 2 federal cases. Even then, the rule, second part of the rule, after we go through the first sentence or the first clause, prohibits juror testimony that would be what is generally known as impeaching the verdict. We're not attempting to impeach the verdict. The second part of the rule provides a juror may testify on the question of whether extraneous prejudicial information was improperly brought to the juror's attention, whether any outside influence was improperly brought to bear on any juror, and then the third one has to do with the verdict having been improperly filled out. We're not addressing that third one. In our proffer, I submit that the juror testimony that we have offered in connection with our notice to the court is exactly what is permitted under the rule, and that is whether extraneous prejudicial information was improperly brought to the juror's attention and whether any outside influence was improperly brought to bear on any juror. I don't know, even today as I stand before Your Honor, how far to go with the gallery here, how far to go in discussing that before the court without going into the specifics of individual jurors and without going into their identity. And I still seek direction on that. We're prepared to go in any manner that the court directs, but I don't know what the court directs on it. I've been doing this for over 50 years. I've had a few motions for new trial. I've had jurors testify, but I've never had a situation where I needed to preserve the anonymity of jurors, and that's where I need some direction. That's the position, is that what we have submitted to the court, what the court has before it, what the clerk does not have before it, is material that we submit fits the exceptions under 606. Now, am I at liberty to discuss that exception now, to talk about what these jurors said, or does the court want to continue to preserve some sort of anonymity?
We don't have to get into the names of the jurors. Jurors identified by number.
Then I'm sorry.
There has to be a proffer for the court to make a rule. So I think everybody's generally in the same zip code here with 606. But we need, well, in my understanding, there may be a second issue out there, which nobody's really brought up at this point, having to do with answers that are more dire.
That's correct, Your Honor.
But there has to be some, I need to know what it is that specifically under Rule 606, or considering Rule 606, that the defense intends to present that would be relevant and material to the motion for a new trial.
If I might refer to the notice that we gave to the court for a moment. I am prone to falling and can't get up when I do. This is from the notice that we presented to the court. The notice was filed without the exhibits on October 7th of this month, October of this month. I had in earlier filings with not with the court, but in exchanges with the state, had certainly not withheld this information. The state would have known what we were doing. The attachment, the first is in Exhibit A, which is the affidavit by the investigator who conducted the interviews. And there were several issues involved in these discussions. And we'll just go by number in sequence. Juror number 79. At page 8 of that interview, recorded, and the court has the transcript. When I say the court, I need to distinguish between Your Honor and the court in some way. The clerk of court does not have this.
Is this all in this notice of intent to present evidence from jurors?
Yes, Your Honor. That was submitted to the judge and to the parties. Not to now the covering notice was sent to the clerk and has been filed, but we did not, and we specifically noted that we were not attaching the exhibits to the notice as filed.
So let me, and maybe this will shorten this up. So the proffer that you intend to make would be these jurors' statements. So differently, limited to jurors' statements contained in this notice of intent?
No, Your Honor. It's broader than that. This was just excerpts from those recorded interviews that we believe fit the exceptions under 606. And with the entire interviews, one is 80-some pages. That's for Juror 580, Juror 380, and Juror 79 are shorter. I think one is 41 pages and the other is 50-some-odd pages. But we have those here in a form that we've marked them as exhibits, the entire interview, and intend to proffer them to the court, at least to make a proper record as to what the substance of that was. What you had in the way of exhibits to the notice was excerpts which we felt illustrated that the jurors, and of course it's hearsay as long as we don't have these people here to testify. That's the reason we've subpoenaed them. What we have now is what the affidavit from the investigator is not offered for the proof, to prove the truth of what these jurors said to him. It is offered not as hearsay because it is simply testimony or an affidavit to the effect that this is what the jurors told me, not that this is true. Now, in order to deal with the truth of it, we would have to have the jurors here to testify. And that's why we subpoenaed them.
I'm just trying to figure out what we need to work through. There's a legal issue on Rule 606.
Yes, Your Honor.
Let's stick with it. Mr. Chaplain, Mrs. Zeller, are you going to be adding anything on the legal side of this, or are we really getting into the problem?
No, Your Honor, nothing on the legal side.
No, I think we all agree with the law. It's a question of whether or not the proffer fits the standard.
Yeah.
That's it, and just whether or not the counsel is going to, this is going to have to
So let me set the stage then for whatever this proffer is going to be. So did look at the notice of intent.
Yes, Your Honor.
The excerpts from these jurors. And I guess I'll try to present the guardrails that I see and then see where this problem is. There's two issues as I understand it. One is there was a juror who apparently appeared at the courthouse on the weekend. Well, really, there's three things raised. Yeah, the juror who appeared on the weekend, this one issue. Question of whether or not a juror held a bias that was undiscovered in voir dire. And then finally, there are a number of statements in here from a couple of these jurors about what they thought of the charge. Okay.
Yes, Your Honor, that much is submitted because part of our motion is that we contend that the court erroneously charged the jury with respect to the law of citizen's arrest. And that's something that I assume that you and I will continue to disagree about, and which is what we do, lawyers and judges. Well, I've had one of the things I wanted to do, and the sheriff said I had to get your permission, is I wanted to record this proceedings because I've been at it a very long time and I've had one motion for new trial granted. Judges like to say if there's an issue, they like it to go up because if you grant the motion, there may be some finality. And I fully understand that this court, at least statistically, the odds are that this motion will not be granted. But my job then is to create a record that we can appeal on. And that's an appropriate approach for a judge, because if you were to reverse your various rulings in the court, then we'd have some chaos as to where we are, and we'd be granting a new trial, and the Supreme Court needs to pass on these. And I understand that will be. I'd be surprised if that is not the court's attitude. And the reason I wanted to record these proceedings is because I hope to continue to represent Travis McMichael in an appeal to the Supreme Court. And I wanted to record and create my own transcript and get ahead of the game so that I can begin working on that. That request is before the court. I did not bring the recording information here today because my assistant, who would be here and will be here, is not available this morning. So that's just asking the court. That's kind of off topic. The proffer, and I'd call it a pre-proffer, is with this notice of intent, is to submit to the court, this is what we hope to proffer to the court. And it just is excerpts from the transcripts. And the transcripts have not been authenticated beyond this affidavit. And as Ms. Donikowski has correctly noted, that this is hearsay. But has not correctly. She has said it's hearsay, and it would be hearsay if we were submitting it under Rule 801 to prove that these jurors told us the truth. It's just an affidavit to establish not that it's truthful, but that this is what the jurors told us. And then they would have to come and verify or deny that they said these things. And that's when the actual evidence would be. What I've brought is transcripts, the full transcripts, marked as exhibits, which I certainly don't want to read to the court. There's hundreds of pages, but Mr. Wilson, the investigator, has compared them to his audio tapes and will testify that they are correct and accurate statements of what was in the audio tape. Now, one of the jurors said,
We're getting way out.
well, I was just going,
Get back to where
sure.
So we've got these three issues. First, let me address the easy one first. As to any juror statements about the jury charge, that's not coming. Whatever the jury thought of the jury charge, their impressions of the jury charge, all of that gets directly into the deliberation of the panel, which is clearly not permitted under Rule 606. So that is not coming.
We respectfully disagree and understand that the court overrules any objection we have on that. Our position on that is not what how they deliberated, it's how they interpreted the written charge. And one of the jurors even talked about on the rule of pertaining to citizens' arrest that we applied the new law and not the old law. Well, there is no new law. The old law was just repealed, and we had to do it according to the letter of the law. So that we.
The issue that goes directly into jury deliberation, they would not have received a written charge until they were in deliberations.
That's correct.
And just further confirms to the court that concerns deliberations of the panel. The next issue.
Well, respectfully, when we tender the recorded interviews, we will tender the entire interview and respectfully submit that it is appropriate and not fault.
You can create your record, that's fine.
That's all I'm doing here, Your Honor, and I think I've indicated that's all I expect to accomplish today.
The second issue is the juror that was alleged to have appeared at the courthouse during the weekend. I think Rule 606 makes very clear that it would be permissible to determine whether or not that juror was provided any extraneous information. But that's where the inquiry stops. Other than whether that extraneous information, I guess, was actually provided to any other juror. What the impact of that extraneous information was, if it existed, and how it was addressed by the panel individually, I mean, subject, is not an area that we're going to get into. The argument then, from the court's perspective, is if there was any extraneous information, whether objectively that could have had any impact upon the panel, if in fact it was shared. And that's going to be the limitation on the court's ruling.
Again, Your Honor, I understand the court's ruling. We respectively disagree. The testimony that we're addressing in that particular instance is that this juror, during the demonstrations, after the court had instructed the jury to stay away from interaction or hearing or talking with anyone, he went. There was apparently a hot dog stand or food trucks or vendors out on the grounds around the courthouse, and he came down. His transcript says he came down, purchased a hot dog, and listened to people who were making speeches of the nature that I suspect was justice for Ahmaud. But he described what they said was, in his words, blah, blah, blah. I mean, he didn't go into detail about it, but if he was listening to people making speeches at the rally for Ahmaud, we can only assume that he was not hearing things that he was hearing things that he should not have been hearing, and that is an extraneous injection into his deliberation. Now, the law is not, and I'm familiar with the cases that the court's relying on pertaining to whether he shared it with others. But there's a presumption, and this is one of the places we disagree, or the Georgia Rule Supreme Court has a different interpretation as to Rule 606 as opposed to the federal courts. If we show this is inappropriate, it's misconduct, and there is then a presumption of bias or prejudice or against the state. The state then has to prove beyond a reasonable doubt, not not by preponderance. They have to show beyond a reasonable doubt that it did not impact did not impact this juror. That's the difference between the federal and the state application of 606, and that's in the Harris case. And then there's an additional argument with regard to that juror having to do with his responses in voir dire, and that's not the issue right now we're talking about, but I can bring it up. Okay.
It's the third issue that I was about to address.
All right, John.
It's indicated where I am on the first two issues. As to the question of his answers, there are some questions and answers in this notice of intent, affidavit, however you want to describe it, indicating his personal position about certain things. The issue for the court is, as I understand it, whether there was a material falsehood that he presented a material falsehood during jury selection with regard to any bias, and whether or not that material falsehood resulted in prejudice. That is what we're going to limit any inquiry to, whether or not there was a material falsehood during the jury selection. Now that's, I will just candidly say, you're going to have to get into a very, I assume this has been done, and he gave extensive answers during jury selection, which are in the transcript. So the issue isn't so much what he said, but whether or not what he said, as compared to what was going on during jury selection, indicates to the court that there was some material falsehood.
Respectfully, and the state has honed in on his truthfulness in individual sequestered voir dire. Our issue is, or our point is, that it was false when he answered, along with all of the people on the panel, the general voir dire questions, not the individual voir dire questions, when he said there was no bias or prejudice resting on his mind. And that's where we address his falsehood. Because of the things, let me get the language. I may have... And in our amended motion, I addressed it at page 12, Juror 380 concealed his bias in favor of the Arbery family. And of course, to even get to individual sequestered voir dire, you have to pass the general voir dire, in which you declare that you have no bias resting on your mind. And if I might read some of this to the court. My investigator asked, what were your thoughts? This is from the transcript, which I understand has not been authenticated or presented to the jury, but this is what we expect the transcript and the recording, and we have the recording, would say. What were your thoughts when you were selected as a juror? To tell the truth, I felt sorry for the family, so I said, Lord, I feel sorry for the family. You want me to help them, then I don't mind helping. Don't mind doing it. Like that, just as I was talking to you. But when you say, this is the question, you felt sorry for the family, did someone talk to you about sitting on the jury? No, nobody. Let's grab my glasses. which I'm sure I dropped somewhere.
It's still back there.
Thanks. Could I get you to pick them up for me? I can't bend over. Thank you, sir. I appreciate it. All right, I'll go back. When you say you felt sorry for the family, did someone talk to you about sitting on the jury? No, nobody. I didn't understand what you mean, felt sorry for the family, the investigator's question. And his answer was, I felt sorry for the family and everything. That was even before I see the tape, the film and everything. So I talked with the Lord, and this is a very religious man. I sat on his porch last week and talked with him. He's very faith-driven. So I talked with the Lord on the way, going to work. I said, if it's up for me to do this, then I'll do it to help the family. Justice got to be done. Then on the next page, when you say the family, you're talking about Mr. Arbery's family as far as what all they had gone through. Yeah. How much, if any, influence did all these high-profile people coming to this trial and obviously sitting in support of Mr. Arbery's mother, how much did that play in how you thought about the case? Because you acknowledged you felt sorry for the family, and who wouldn't? They lost their son. And Mr. 380 says, yeah. And then the question is, did that have an impact on you? Answer. Not really. At first, I feel, like I said at first, I felt when I found out, this next sentence is one that kind of gives away who he is, but I'll go ahead and read it. When I found out I was the only black, I was like, oh my God, now I'm laying in bed, can't sleep anymore because I felt like the weight of the whole black race was on my shoulder. And I started praying. And the Lord said to me, he said, all you got to do is just what I tell you to do. And I'll coach you through the whole thing. He said, you got to talk with everybody. You can't be quiet because they'll think you're mad. And then he says, I never did get mad. I got a little angry when I saw the tape. And then further down. So the Lord, he set everything up. Anyway, after I prayed, I cried for the family, and it turned to a joy cry, and didn't even know I had been picked for the jury yet. When he did not make these feelings known in response to the general voir dire question, have you formed or expressed any opinion?
That would be argument. So what I was simply saying is the issue before the court is that you are alleging that there were material misrepresentations made in voir dire.
Yes, Your Honor, it's a material misrepresentation in the form of not acknowledging because it's a general voir dire question posed to the entire panel.
And let me remind everybody, because I know some folks did not participate in voir dire, that voir dire was a two-step process to voir dire. There were general questions that were agreed to by all counsel, and then based upon the general questions, each party was then given the opportunity to indicate to the court whether they wished to have the juror come to individual voir dire. Juror 380, we're talking about, went through individual voir dire, which was then a process that allowed clarification by all lawyers, because all parties then would have an opportunity to ask that juror questions. And so that's why I have indicated a couple of times now what I would expect if we go down this road with any of the jurors, is that there is reference to that juror's answers to voir dire. Because whatever he has said now is all well and good, but that's not what we're looking at. The issue before the court is whether there was a material misrepresentation during voir dire, ultimately that prejudiced the defendants. And so the ruling of the court is we're not just going to get into these statements. There has to be some reference for the court to statements or positions, opinions, because all of these different things were presented during the voir dire process. Because my understanding is these statements were provided months, 6 months, 8 months, 9 months.
No, Your Honor, the recording, the interview was roughly 6 months after the trial. The focus of this is what was this juror's attitude and bias when he did not, when he was asked, along with the rest of the panel, when he was asked if he had any prejudice or bias resting on his mind. Now,
I've indicated where the court is. There needs to be a record, because there is an extensive transcript on juror 3.
Yes, Your Honor. And
general voir dire was followed up on by all the parties. So I've looked through it, not in the detail that I'm going to ultimately have to, but I know based on my preliminary review of juror 380, and that there were questions. Let's see, Mr. Rubin, on behalf of your client, did the individualized voir dire. He was asked about his opinions, whether he could put any of them, received some pretty straightforward opinions. Specifically asked by Mr. Rubin, again, representing Travis McMichael at the time, whether or not he could put any of those issues aside and listen. So again, the court is going to need more than simply statements made 6 months after the verdict. The issue before the court is whether there were material misrepresentations made during the voir dire.
And we respectfully submit that this portion of his transcript reflects that he got on the jury so that he could help the Arbery family. That and I maybe stated too strongly in my motion, but we look at him as he was there to assure that there was no acquittal in this case. That's why he was there. That's what the Lord directed him to do. Now, I sense the court's ruling.
Well, you don't need to sense it. I have provided it.
All right. Well, that said, we still stand on our position and take the position that this evidence, when it becomes evidence rather than a transcript of which would now be hearsay, but once he testifies, it shows that he got on the jury by not disclosing that he had a bias in favor of the victim's family. And that it guided him. It guided him so much that the Lord told him what to do. And we'll stand on our position. I hear the court's ruling, and I certainly understand the court can make the ruling. The question now for me is, what may I proffer to the court? And if the court, I would at least submit that our notice of intent to present jury testimony is an adequate proffer of that issue. We have to submit the exhibits to the affidavit, which we didn't because we were protecting juror anonymity. At the same time, I submit it's an issue that needs to be decided in Atlanta, and that's why we want to create a record here.
I understand where. Anything then from Greg McMichael? No, from Mr. Brown.
Are you asking on everything that?
What we've addressed, well, let me ask to be more specific, because I'm going to go around the room to make sure everybody understood what the court's position was in ruling upon the three matters that we've now discussed with regard to these jurors being called and what the court will allow for testimony. Any questions about that?
I did want clarification on position number 2. you allow for testimony on, I guess, the outside influence, or the extraneous information, but not how it affected the deliberation?
Not how it affected his deliberation.
Right.
That's an objective inquiry.
Right.
So objective inquiry for the courts and objective, I guess the argument would be from the defense perspective, an objective argument on how that influenced or could influence the panel to the point where it could be impactful, given the standard of the courts having it.
So will we be able to show the type of influence that was around the court that day, or that during the trial?
The court's ruling is this juror is being called because it's my understanding that there's a belief that he received information extraneous to the court, from outside the court. I don't know that he did, based on what I've seen in the affidavits, but I'm not sure specifically what that is, but I'm going to permit inquiry into whether or not there was anything extraneous in there. Then we'll also know whether he mentioned it to anybody else. But as far as whether he considered, or how he considered that during deliberation, or what he thinks any impact of it would have been on the deliberation, we're not going to get into it.
Just one follow-up on that. Also with regard to 606, it says whether any outside influence was improperly brought to bear upon any juror. So would he be able to talk about the outside influence that he witnessed, or
That gets into deliberation.
okay?
Your Honor, I'm sorry, I didn't mean to interrupt.
I think the record is very clear on what was going on. I believe Mr. Goff, on behalf of Mr. Bryan, has made a very clear record as to what was going on around the courthouse during the time of the trial in this case.
I was going to I have a list, right, so I don't need that. You're correct. And I agree that it's not the law is clear that jurors can't say how it impacted their deliberations. I think the law is clear on that. That's the objective. On the last issue, I think we talked about juror 380 and the misstatements under Verdier. Is that correct? I will just add one thing that I do have in my notes, and this was when I read the transcript on page 2156. There was a notation from Mr. Dahl that the juror had nodded at the victim's stand. The juror nodded at the victim's stand after he was walking out. So that was something that was raised during, and that was brought in part 1. That was the notes I had. His individual started on page 2100, and he was walking out on 2156 is when Mr. also, in my note, this is what I wrote down. He says that the juror nodded to the victim's family as he walked out, but he didn't ask for anything. And later on, when the court asked for a structured cause, that he was not, there was no motion to strike the cause. So I just want to point that out.
During the hire itself.
Yes.
At the end of the individual aspect. Yeah, I don't have my in mind. I can't remember whether there was a motion for call. So
There was not a motion for call from 38. There was not. That was in the very next, that was volume 9, part 2, motion for calls for those that 10.
From the state, any question not to get
No, Your Honor.
Two points. One, I worked very closely with Mr. Chappell, representing Greg McMichael. I represent Travis. My understanding is he adopts in full what we've argued here and what we presented in the motion.
Yep, we're both on the motion.
And the argument I've made here today. Right, Your Honor, I have heard and will certainly abide by the court's rulings. I must admit I'm not 100% certain where you are limiting me in terms of presentation.
I don't think I can be any more clear.
Well, and am I going to be permitted to have my investigator come testify regarding the accuracy of these transcripts? I'm not going to ask the court to look at the transcripts or read the transcripts. There are hundreds of pages, but he has authenticated.
I can't tell you how to present
I'm not asking, I just want to know, am I limited there?
Somewhat objection. I don't know what your case is going to be. There are 3 specific issues of law that I have presented.
I understand.
However, the defense then wishes to present a motion for a new trial. Given those rulings, we are here to address today.
And I want to make an inquiry with regard to such things as the motion or the notice of intent to present juror testimony, which we filed with the clerk without the exhibits because we were trying to protect juror anonymity. I would be permitted, I assume, to file that with the exhibits attached after this hearing.
So, I have not been asked to seal those by any point.
I'm sorry?
I have not been asked to seal that by any point.
Well,
Because of that, at this point, the court can't sua sponte seal it. The court has tried very hard during these proceedings to ensure the anonymity of the candidate for a variety of reasons that I don't need to get back into. And that has been respected throughout. Yes, and I would suggest this may be one of those cases. There is something that is being submitted to the court that any one of the parties believes may create an issue then for the jurors, then that needs to be submitted to me with a motion to seal it. I need to hear from the parties, but then I need to have a hearing under the rule to ensure that the public interest is not outweighed, or that the public interest is outweighed, I should say. And then I'll seal it. But it's not the court's duty to just seal records.
I fully understand that, Your Honor, and frankly, from the defendant's standpoint, from Travis Michael's standpoint, it doesn't matter to us whether it's sealed, but given what the court has just said, we move to file the entire motion with exhibits under seal. It was filed, Your Honor, with the court. The notice of intent that was filed, let me get the stamp. The stamp we have from the clerk's office is that the covering motion, not the exhibits, were submitted and filed with the clerk of court on October 7, 2024 at 4:28 in the afternoon. We would move to allow us to submit now the exhibits under seal, given the court's observations.
Well, we're going to have to address that at the times. I need to give everybody an opportunity to consider that as well as the public.
And I want to make it clear from our position, we don't care whether it's under seal. I'm trying to abide by the court's concerns.
What we're going to do for the time being is the notice of intent will be in the record. We'll hold off on the attachments until the court's had an opportunity to consider the motion to seal.
Thank you, Your Honor. I believe that's all we have preliminarily. I will present at the appropriate time, and Mr. Lamar, who practices law with me, will present the testimony from Mr. Wilson regarding other subject matters. I'm just here to address the proffer. I will call Mr. Wilson for the proffer, and then he will, when we get back to the other issues, then Mr. Lamar will take my position. I'm very concerned under the rules what is necessary to authenticate. This is not a situation I've faced in 52 years with all of the anonymity. And so I'm concerned that I don't run afoul of any rule of this court and yet follow what I understand to be the law. And I believe my understanding of the law is that we need to proffer these affidavits as exhibits, and I'm sure that we'll proffer them under seal as well because they're extensive and probably, according to the court's observations, they do not need to be available for public review.
The court's already ruled on this. That's the reason I asked the question about the notice of intent and the jurors who were listed and the statements that were made. And what I was told is that is effectively a summary of what the statements were. The most material statements being part of the affidavit. I understand what the proffer is at this point on those specific jurors. And just to be clear for the record,
Jurors 79, 380, and 580.
'79, 380, and 580. Yes. So, you have addressed what you believe those individuals would be testifying to, and I have ruled. I have not ruled that those individuals cannot be called. I have indicated what the court's position is and what the limitations of their testimony will be.
I understand, Your Honor. Because sometimes I'm a little slow on the uptake, I think I understand the court's rulings. If I come close to violating them, it's not intentional. That's where I am. And also, we viewed the notice of intent, I called it a pre-proffer, just to give the court an understanding of why we believe that this testimony does not violate 606. So,
It sufficiently apprises the court as to the issues. I've ruled on the three issues that I see are raised by the defendants proposed to call them witnesses. In the context of the court's rules, let's go ahead and move on to the motion for new trial.
all right, then I believe Mr. Bryan is going to go first with regard to the substantive portion, and then we'll follow. You can grab my cane. Thank you. My legs get very weak. Thank you, sir.
There's been some discussion during our brief status about the presentation. Mr. Giselle has volunteered to go ahead and move forward on the motion on behalf of Mr. Bryan. First, I do have the filing of the motion, amended motion for new trial was filed on May 22nd of 2024. The state has had an opportunity to file a written response. I'm receiving by email. I'll send it to Brian.
Yes, Your Honor.
So the matter is Mr. Bell.
Thank you, Your Honor, and yeah, I'll do whatever anybody wants me to. Go first, last, in the middle, somewhere. I filed my motion, Judge. My intent was just to present the issues that I thought needed evidentiary support that were required to be presented before appeal. I do not intend to relitigate issues already raised at the trial or pretrial, which just leaves the two issues of ineffective assistance of counsel.
So you're preserving everything in the motion?
I think everything was adequately preserved. All the other motions, I'm not going to ask. I know Ms. Dunikowski's brief got into many other issues that maybe were raised in the original motion filed by Mr. Gow, but I'm just focusing on these two, and Mr. Gow's here, and I would just, if one of the bailiffs could sound for him, and he's out in one of the witness rooms, unless Your Honor wants me to go get him.
No, that's fine. If we could go ahead and Mr. Kevin Goff.
Golf.
I just call him Kevin, so I never got his last name. All right, if you could state your name
Kevin Goff.
and what is your occupation?
I'm an attorney.
And are you licensed in the state of Georgia?
I am.
How long have you been licensed?
Since June 1987.
And do you generally practice criminal law?
Yes.
Okay. Briefly, can you just give us some of your experience as a lawyer?
I worked for a federal judge in Montgomery, Alabama. Served as law clerk for a year there. I was in private practice for a year. I came here doing assistant district attorney until '89. Assistant district attorney until June of '93. I went into private practice at that time. I remained in private practice until August of 2012, when I became circuit public defender for the Brunswick Judicial Circuit. I held that position until April or May of 2016, and went back into private practice, and I've been there since.
Is that, and at some point you came to represent Mr. Bryan?
Yes,
Okay. And were you in private practice at the time?
I was.
Hey, were you appointed? Were you retained?
I was retained.
Now, I don't think it's a secret here that you knew that Mr. Bryan was subject to some criminal action or suspected criminal action in this county before you were hired?
Yes, I was originally hired for pre-arrest representation.
Okay. Do you recall when you first spoke with Mr. Bryan?
I don't.
Okay.
It would have been probably in April or early May, but I can't be any more specific than that.
Okay, so Mr. Arbery's death was February 23rd, 2020, and so sometime a couple of months later, we have a time span of middle of April to 1st of May.
The McMichaels were arrested, and I think at that point in time, the urgency of Mr. Bryan's situation became clear.
Okay. Now, do you recall the date the McMichaels were arrested?
I don't recall the exact date. I believe it was in early May.
Okay. Does May 7th sound accurate to you, or would that be consistent with what you recall?
That fits the time frame.
Okay. And we went over some of these timelines to kind of refresh your memory. So do you recall when you actually formally entered into any kind of agreement with Mr. Bryan to represent him?
May 8th.
Okay.
There's a check dated that day and a fee dated for that day.
All right. Now, prior to May 8th, did you have any conversations or communications with prosecutors, police officers regarding Mr. Bryan?
I don't think so. Prior to May 8th, my recollection is that either Mr. Bryan or his wife had reached out to me about his situation, and I encouraged them to seek other counsel at that time, and it didn't work out. But it had to be around, May 8th was the day I was formally retained.
Okay. Would it be fair to say that you then talked with Mr. Bryan? I'm not asking you to repeat what he said, but talk with him about what transpired?
Yes, we probably had a brief conversation, maybe over the phone before that, but we really didn't get into the details of it until May 8th.
Okay. And at some point, Mr. Bryan met with Agent Sechrist and made a statement?
Yes. I think when if I recall correctly, when Mr. Bryan retained me, the GBI had reached out to him the day before, maybe, or the day before that, or maybe earlier in the week. They had reached out to him and they wanted to interview him. And he came to me because they were expecting an answer. And I think we put off the GBI. I think it was agency, but we put the GBI off at least over the weekend, trying to get a better idea of what was going on.
So May 8th, you begin your representation. The first interview is on May 11th. Is that?
I believe that's right.
Okay. So between May 8th and May 11th, did you have any conversations with any prosecutors, district attorneys, or police officers regarding Mr. Bryan's case?
It's difficult for me to recall that now. I can't really refresh my memory from that time frame. So it makes it hard for me to answer that. But I did, I know that we would have talked, that, got the information we could. A lot of the information that was available was, frankly, coming through the media. Information leaked or appeared to have been leaked, whether from Lincoln County PD, GBI, the Arbery family or their attorneys or whoever. There's no way at this point in time I could speculate where the information was coming from. But there was information. There was a short snippet from the video that Mr. Bryan had made at the time of the shooting, and that turned over. But I'm not sure he retained a copy of it. But there was a snippet of it, or a snippet of the video from the actual shooting that had made it in the media, and a few other things. There was a lot of misinformation. I didn't really spend a lot of time looking at the Arbery matter until Mr. Bryan indicated an intention to retain me. I know that sounds weird, but this is my living. I generally don't pay attention to the cases that don't involve me. So I didn't have a whole lot of information before Mr. Bryan retained me.
Okay. So as far as talking to anybody from, whether it was the Brunswick Circuit or the Atlantic Circuit or the Cobb Circuit, you had no conversations between May 8th and May 11th?
With the prosecutor?
Yes.
I believe so. I think I had made a point of pointing out that I wasn't getting any responses to inquiries. But at that time, from what I can see, technically, Joyette Holmes had just gotten appointed or just gotten into the case, and Mr. Durden had exited, was just exiting. The GBI had different reasons why I was having trouble getting in touch with people, and those explanations were plausible at the time. It may also well have been that they just didn't want to communicate.
Okay. Prior to May 11th, you attempted, then is it fair to say you attempted to contact somebody from the Cobb County District Attorney's Office but received no reply?
I'm pretty sure I reached out to a prosecutor. I can't recall who was the
Okay. Now,
but I do know that I had mentioned to the GBI on more than one occasion that I was having difficulty communicating with prosecutors and their concerns.
was it Agent Seacrest that contacted Mr. Bryan, to your knowledge, about doing an interview?
I can't recall whether Agent Seacrest contacted Mr. Bryan or another GBI agent initially contacted Mr. Bryan and let him know that Mr. Seacrest would be wanting to interview him. That much I can't recall, but Mr. Seacrest seemed to be the lead agent at that point in time in dealing with Roddy Bryan. And there was a lot of investigators down here. The GBI had temporarily taken over offices in the DNR complex, for lack of a better word, off to the side of the Sydney Linear Bridge. And there seems to be a lot of people. But I believe Agent Seacrest was the lead officer with respect to Roddy Bryan.
Okay. Did you speak with Agent Seacrest then prior to May 11th?
I think I did. I'm pretty sure I did. It's possible it was text instead of calls, but I'm pretty sure. Yeah.
Any other agents you recall any specific names of anybody you might have spoken to?
Agent Dial was kind of out there. But I can't specifically recall what his exact role was with respect to Mr. Bryan in this time frame. But there were a bunch of DBI agents floating around.
Okay. From May 8th to May 11th, whatever time the interview started, did you speak to anybody in the Glenn County, the responding police department's office about anything they may know about the case?
I can't tell you that I spoke to any particular Glenn County Police Department officer. I made some inquiries around. This is a small town, but I can't recall any specific conversations with specific individuals at this time.
Okay. And it seems that the freshest thing in your memory is Agent Seacrest. So with Agent Seacrest, did he give you any information about anything he uncovered in his investigation or the police department or GBI's investigation to that point in time prior to the May 11th interview?
I don't recall Agent Seacrest sharing a lot of information. That's generally not how this works. They generally try to give out as little information as they can while getting as they can. They did have to share some details because they couldn't really ask Roddy questions without sharing. I mean, they had to inform him of some things so they could inquire, but they didn't share a whole lot. I do remember being told, don't believe what you read in the papers, things like that.
Okay. Had you received any, back it up, were you aware that Mr. Bryan had made statements to the Glenn County Police Department prior to May 11th?
Yes.
Were you aware those statements were recorded?
Yes.
Had you seen those or heard those prior to May 11th?
That small snippets of the body cams may have been in the media by that time, or information from them had been put out there in the media from whoever. But I don't recall any specifics, but I know there was a lot of information that the vast majority of those interviews that I did not have access to.
Would you rely on any media reports in representing Mr. Bryan or any other client you may represent?
Depending on the circumstances, I'll utilize any resource that's available if I feel I can rely on it.
Okay. Would the best evidence of what Mr. Bryan said be the actual interview or a media report of what they have garnered from some leak?
The absolute best information as to what Mr. Bryan said to law enforcement, the best information would be the body cam videos themselves from the officers. And there were multiple officers on the scene the day of the shooting. And some of their cams picked up more of the conversation, some of those picked up less of the conversation. I also had the benefit of Mr. Bryan, as my client, to recount as best he could what was said. People tend to recall things the way they want them to be. And in retrospect, maybe his initial explanation of what was said was a little more favorable to him, slightly more favorable than the actual videos turned out to be, but all in all, it wasn't a day and night difference. I mean, he legitimately tried to the best of his ability to tell me what had gone on that day.
Would that be unusual that what a defendant tells you is not actually what is reported during a statement?
Clients lie to lawyers all the time in the initial stages of the case, but in this case, for the most part, I thought Mr. Bryan was very truthful. I thought he was, to this day, I can't say that I ever caught Mr. Bryan in a lie of any kind. I mean, he may have embellished or understated things, but generally speaking, we had a very good relationship, and I never had problems with him like I did with some clients where I walk in the courtroom and they get blindsided.
In addition, not just lying, but maybe memory issues or perceptions or stress of the event, or those other factors that weigh in on whether or not Mr. Bryan or any other of your clients are able to recount exactly what they have informed the police?
Yes, clients under stress are often less reliable reporter to this. Mr. Bryan was under extreme stress, and he is an individual I could certainly say today, if I couldn't say in May of that year, certainly someone who doesn't respond especially well to stress. That was certainly a factor that entered into decisions made later in the case, as to, for example, whether he would testify.
In addition to the body cam on the scene, did he not also go to the Glenn County Police Department and make a formal statement as well before your representation began?
I think he might have made 2 statements.
All right. So going to this May 11th interview, do you recall any conversations you had with Agent Seacrest about the parameters of this interview?
Yes. As I explained, I was trying to buy time, among other things. I wanted to get a polygraph examination for Roddy. And I wanted to be able to do what I could for Roddy, and the more time I had, the better off I was. On the other hand, it seemed pretty clear, having already arrested the McMichaels, that the GBI would have probable cause to arrest Mr. Bryan if they chose to do so. He was subject to being arrested at any moment. So pushing back the cooperation with the GBI beyond a certain point was simply going to trigger his arrest. So that was a balancing act. Once Mr. Bryan was arrested, it's difficult to unring that bell with the entire world watching what you're doing. Once the GBI made the charging decision and arrested Mr. Bryan, that was kind of, in many ways, an irrevocable decision. There was no coming back from that. So I didn't want them rushing to do that either.
Prior to the May 11th interview, were you aware of what, I guess, subsequently came out at trial, or you probably learned through discovery? Some of the Glenn County police officers, when they interviewed Mr. Bryan, said that Mr. Bryan recounted that he boxed Mr. Arbery in, things of that nature. Were you aware of that before the May 11th interview?
I don't know if Mr. Bryan used the word boxed in, but he was reasonably candid that some of the things that he said to the GBI probably wouldn't sound good. He's just not a very capable person. I don't know that the full, exact flavor of some of that stuff was fully there. I mean, it was a little worse. Looking at the statements that were made, it was somewhat worse than what I had hoped for. But I can't say that Mr. Bryan misled me as to any of that. So I'm not sure if that's helping you. I'm trying.
No. I just want you to testify as to what happened, what actually transpired. So when Officer Minshew testified during the trial that Mr. Bryan said he blocked and cornered Mr. Arbery during the chase, and then went on to how many times and that's according to Officer Minshew, of course, that Mr. Bryan blocked Mr. Arbery in. Were you aware of that before May 11th?
I can't recall whether what I can say is this. Mr. Bryan did alert me that there were things in the statements he made to the police that he was concerned about that were probably not helpful. Did I have the exact full flavor of it? Not necessarily. But there were real issues with what he had said to the police. Among other things, my recollection is that Greg McMichael was doing his best at the scene of the crime to dictate not the word for it, direct the officers in their work. And, I always felt that Mr. Bryan, what he said that day was partly in response as much to what Greg McMichael was saying as to what he was actually seeing, doing, and looking at the videos, the body cams from that day. I felt that some of the things Roddy said were probably not exactly right, but he just kind of went along with what was going out there. The problem is you're stuck with that. When you make a statement to the police, you have to live with it. There's no coming back from it. It's not something you can really argue with the jury.
Would it be fair to say that you did not actually speak to Officer Minshew before May 11th?
I'm pretty sure that I did not talk to any of the Lincoln County police officers prior to May 11th.
I'll just ask, that would include ex-Officer Lowry?
I don't recall talking to Officer Lowry.
Now, I've asked you about this blocking and this boxing in. Did you ever advise Mr. Bryan not to use language like that when he submitted to this interview with Agent Seacrest?
I can't recall telling Mr. Bryan what to say. I mean, we always tell our clients to tell the truth, and if you can't tell the truth, then maybe you just shouldn't tell it. As far as word choices, it's possible that I suggested other ways to say the same thing. I can't rule that out. When we did the video with Mr. Bryan on the 13th, I mean, I think I interjected at one point when we restarted the video because one of the GBI officers started out saying something that didn't sound like it was going to come across very well in the courtroom. So I can't rule that out, that I wasn't telling Mr. Bryan what to say any more than I was telling the GBI officer what he could or couldn't say. And certainly in suggesting that if I remember, we went back, we drove 10 or 15 feet, and we pulled back in and started over again. It wasn't like I was trying to tell the GBI officers what they could or couldn't do. I didn't have that far.
Now, you testified that Mr. Bryan was concerned about, before this May 11th interview, I think, is what your testimony was, that he was concerned about some of the things he may have stated to the police before your involvement? Is that?
I think he was concerned.
Okay.
Yeah.
Was that something that was specifically part of that concern, the boxing or boxing in?
Mr. Zell, I'm doing the best.
Okay, that's okay.
I
understand.
I don't specifically recall that he was concerned about the boxing in. I know that Mr. Bryan was concerned that are you really sure you want to get into that? I think Mr. Bryan was concerned that some of the statements that he gave to the GBI might, in retrospect, not look so good. Whether that's specifically boxing them in, trying to run them off the road. There was language that Mr. Bryan used in his statements to the GBI that day, on the day of the shooting, on the side of the road, that were not well thought out by Mr. Bryan, and I'm not sure to this day that they were even true. But Mr. Bryan was responding that day to things that were around him and what he was seeing and hearing. He thought that day that he was with the good guys. Okay? He thought he was doing a public service that day. Now, it didn't dawn on Mr. Bryan until well after the fact that he might have actually done something that other people might think was not heroic. I mean, he thought he was the good guy. And I understand why.
Well, in response anyway, Mr. Bryan's statements were, not only were they played for the jury, but the officers testified to them, and I'm speaking about pre-May 11th. Is that correct?
The statements from the day of the shooting?
The day of the shooting and subsequent interview before your involvement?
Yeah.
Okay. So that came out. So I'm not asking you to reveal anything that wasn't already made known to the public as far as his interviews.
Okay, but when you're asking me about what he's telling me, he was aware that, in retrospect, that he had created some liability for himself with some of his word choices when he spoke with the GBI. And I think that objectively, when you look back, what was said on the side of the road and what was said to the GBI after the shooting, some of his word choices were poor and made it sound like he had been more aggressive than had in fact been the case. And that really put him in an awkward position. There was no question that the GBI had probable cause. If they chose to arrest him, he was subject to being arrested. And if he was arrested, at that time it was pretty clear that he was not going to be released from jail, no matter how many motions for bond would be filed on his behalf. So he had some stark choices to make.
Was there any suggestion, and I shouldn't use that word suggestion, strike that. Was there any advice to avoid using certain language that may have been put Mr. Bryan in this bad light before that May 11th or 13th interview?
I don't recall specific advice in that specific wording. But did we take the time between May 8th and May 11th to review what he would say if he spoke to the police? We sure did. Did we take more time? And we only covered on May 11th certain very narrow subjects, because I was still trying to catch up in understanding the case, which is why we were limited the first time, and we came back on May 13th. So did Roddy and I discuss what his testimony was going to be on May 11th and May 13th, or what his statement would be? Yes, we discussed it at length. Did we discuss how he could truthfully present that in a way that would minimize how he appeared? Sure, we discussed that. You can say the same thing in many different ways, and it come across much worse in some ways than others. For example, if you're going to do a reenactment video of something that happened in a racially sensitive case, we try not to use words like spook, because in some circles that can be interpreted the wrong way. Does that make the person using that word a bad person? No. Does it make it a lie if they don't use that word? No. There are word choices that are not substantive. But yeah, we spent a long time discussing what he was going to say, both on the 11th and on the 13th. And every step of the way, the choice was always there not to go forward or to stop speaking at any time.
Now, between the May 11th, the May 11th you testified was limited, and at some point, Agent Seacrest says, not enough, I need more. Do you recall when that was? And I'm just paraphrasing, by the way.
That was never the discussion.
Okay.
The discussion was, I needed more time to allow Roddy, Mr. Bryan, to give an unrestricted interview because I was catching up.
No, I'm referring to Agent Seacrest. I apologize. I'm referring to at some point during or after the May 11th interview, Agent Seacrest wants another interview. That's what I was asking about. When did that come about?
We always knew that they would want a second interview. It was never a question that he was going to speak to them once, and that was it, because it was limited to begin with. It was always the expectation that there would be a second interview. If the GBI wanted, they could have walked out and said this is a waste of time. But there was never an expectation that Roddy's discussion with the GBI was going to end on May 11th, although we had the option, and we discussed it while we were there on May 11th. We took, and they may or may not be documented in the recorded interview from that day, but there was a lengthy conversation prior to that interview on May 11th. There was at least one recess, maybe two on May 11th, where I had conversations out in the hallway with Mr. Seacrest, and I had conversations out in the hallway with Mr. Bryan, because there was always the option of terminating the interview.
So prior to May 11th, I just want to ask, was it, Agent Seacrest didn't say, hey, I want you to come in for the first of two interviews, did he? It was just come in and I want to talk to you. I want to talk to your client about some matters that arose. Have questions for him.
Agent Seacrest would have been happy to have one interview. He wanted to have a full-ranging discussion with Mr. Bryan. I couldn't give him that because I wasn't comfortable on May 11th with that. But it's not like we did the one and then suddenly it's a surprise there was going to be a follow-up. The question, what I'm trying to tell you, it was anticipated that we were going to be coming back after May 11th.
You believe that Agent Seacrest would want more information, not limited?
Well, yeah.
Okay.
The first thing he had to assess is whether he wanted Roddy as a witness. I mean, that's part of the process, and if the person is unable to function as a witness, then that's the end of the process. And frankly, if I recall, Mr. Bryan had some issues at the beginning. I haven't reviewed the transcripts, and I haven't reviewed the statements, but I vaguely recall that there was some issue. Roddy was extremely nervous, maybe, and we had to take a recess, and there was some question as to whether or not we should proceed or not, and I think we came back in and we started up again.
You know, going back to the original question, which was, at what point did Agent Seacrest ask you to ask Mr. Bryan, or ask you on behalf of Mr. Bryan to submit to the second interview? When was that?
Okay, and I'm trying to answer the best I can.
Okay, sure.
They wanted the ability to have a complete discussion. Police officers don't like to have restrictions on interviews, and sometimes can't do that. They always have the option of arresting them. But the idea that we came in and it was a surprise that we were going to come back again, that's not true. It was kind of expected. The first interview was Mr. Bryan was going to see whether he was comfortable, and the GBI was going to see whether they were comfortable. The first interview, topics were relatively limited. If he came back, it was going to be a much more open conversation.
I understand. I think we've established, though, that Agent Seacrest didn't ask you to come in, hey, can you all come in on May 11th and then come in 2 days later? You come in on May 8th, May 11th and May 13th. You come in on May 11th, at some point, there's got to be some request for you to come back on a different date. And that's just what I'm asking, when was that done? Was that done right after the interview, in the middle of the interview, the next day?
I can't recall when the decision was made to come back on the 13th. I can tell you that I can recall trying to postpone the second interview on the 13th. I wanted more time. There was, Justice Department had begun showing interest in the case. And that creates a whole other level of complication. At some point, I think the U.S. Attorney showed up for a press conference and was standing in the background, if I recall. But however it came up, I wanted additional time, and I couldn't get it. Okay. And it was, at that point, it was either we were going to submit to an interview or not, and then they were going to make a decision.
So the first interview was May 11th, the second was May 13th, so would it be fair to say that there was some request by Agent Seacrest on either May 11th or May 12th to come back on May 13th?
I don't know whether he initiated the date, I initiated the date. What I'm trying to say is it had been anticipated. The GBI was not settling for the snippets of the limited subjects that we had. I think it was anticipated, if everyone was happy with what happened on May 11th, that we would come back at a later date, whether that was the 12th, 13th, or 14th. I don't know that that was clear up front. It ended up being the 13th.
Well, it almost sounds like your answer is that it was maybe your idea to come back a second day, or was it Agent Seacrest?
It was a mutual decision. Roddy had to decide if he wanted to cooperate further, knowing the risk, and the GBI had to decide whether it was worthwhile. But I'm really kind of confused.
I guess it's like one of those things with a mutual breakup. Well, somebody had to initiate it, really. Come on, nobody just at the same time says, hey, let's break up. At some point, somebody had to say, either as attorney, Mr. Goff or Mr. Bryan, we need to cover some more things. Can we come back in a couple days? Or Agent Seacrest says, listen, that's not enough. We need a little more information. I don't think it's just that both that it's kind of, and if it is, hey, I'm wrong. But I don't think at the same time, Goff and Seacrest are talking over each other going, we need to talk more. So somebody had to raise it first, and that's what I'm asking. Who raised it?
I can't recall.
Okay.
I mean, I told you this, Mr. Duff.
Okay.
I mean, a lot of the communications were by text. between myself and Agent Seacrest. That phone broke, and without recovering the information from it, the text from it, it's hard for me to piece together the sequence of exactly when Mr. Bryan retained me, exactly and how and when we set up the interview. A lot of that is in text, and only a sliver of those texts are part of the record in this case. I vaguely recall a handful of those texts being used during the trial, maybe on Jackson v. Deno, but I don't have access to those, and frankly, Agent Seacrest has his phone, and whether they were preserved or not, I don't know. But without having the benefit of going back through the communications in that time frame, it's hard for me to be more specific.
Okay, so you don't recall whether or not it was you or Agent Seacrest who initiated the May 13th interview?
The GBI always wanted more information. That's my recollection. And that I've never known a law enforcement officer that didn't want an opportunity to speak with the defendant. And there were other issues out there. There was certainly other information that Roddy could provide that maybe they weren't aware of, like the Night Owl video. I'm not sure, but it may be that we volunteered those, the existence of those. There were issues with Roddy's cell phone, and if I recall the video, because the police couldn't get the video, they got a snippet on the side of the road that day of the shooting. Then Roddy brought the phone back a second time, and they had issues. Mr. Bryan may have brought the cell phone back to them a third time before he retained me. But they were still apparently having some issues. They wanted access to the phone. And there were a number of things that the GBI was interested in besides Roddy's actual statement.
Okay, between May 11th, when the interview concluded, and the second interview on May the 13th, were you able to obtain any evidence or statements or videos or recordings from the state, district attorney's office, the police, or any other source that gave you more information on the case other than what Mr. Bryant was able to provide you?
I don't believe so. Okay. It's possible that Agent Seacrest provided something somewhere along the way that week to help Roddy refresh his memory, but I don't recall it.
Okay. So from May 11th to the May 13th interview, were there any other attempts or discussions with the Cobb County District Attorney's Office?
I don't believe so. I believe that it continued to be, I could be wrong, but I think it was more or less a blackout situation where we couldn't get in touch with them, and it was concerning.
Then it's fair to say that your communications with state agents, officers, was strictly with Agent Seacrest during this period of time from May 8th when you began your representation to May 13th when the second interview concluded?
Agent Seacrest was the primary GBI agent who was responsible. There were always other officers around.
I'm speaking of who you had communications with. Would it be just Agent Seacrest?
Some of those officers were present on May 11th. Some of those officers were present on May 13th. I can assure you, Agent Seacrest didn't go into Roddy Bryan's house alone. And I can't rule out the possibility whether there were conversations with other agents as well. The ones that I remember are with Agent Seacrest.
And when I'm saying that, I'm referring to communications outside the actual interviews.
The communications that I remember were with Agent
Seacrest. Did you, with Agent Seacrest, you attempted to, your goal was, I take it, to have Mr. Bryan a witness as opposed to a defendant? Would that be fair to say?
Oh, absolutely. Mr. Bryan is much better off being a person of interest or a subject and a witness than being the target of an investigation.
There was, prior to either interview, May 11th or May 13th, were there any agreements to that effect?
There was never a legally binding agreement for Mr. Bryan's testimony, for his cooperation. And Mr. Bryan was well aware at all times that we never had that. Now, at least in this part of the state, there's a long history of what we call non-deal deals. Okay? Sometimes the prosecutors are involved in those directly. Sometimes they're not. In a non-deal deal, at least in theory, if you're a prosecutor and you believe in that sort of thing, you don't have a deal, but you're getting the benefit of the deal without any of the liability associated with that at the trial of the case. And in this case, this wasn't a situation where Mr. Bryan was seeking a deal in the sense of a plea agreement, because Mr. Bryan wasn't prepared to plead guilty to anything. Nor was this a case where Mr. Bryan was going to be obtaining immunity from prosecution, because among other things, it was way too early in the case to have a discussion about immunity. And you also had the federal investigation ruling as well. And any deal that was struck with the state, you'd also got to run that by the Justice Department, who shockingly was very reticent about committing to anything about anything in this case in the early on. But there was a discussion, and I think I mentioned it to you this morning because I went back through my notes. Maybe that's what you're asking me about. No, but I do recall that, let's see if I can find it.
Well, I'm just asking in general, was there any deal?
Well, obviously, we wanted the state to publicly come forth and say that Roddy Bryan was not a target of their investigation, that he was merely a witness. And there were various reasons for that. And Agent Seacrest did his best to walk that fine line between being encouraging and putting forth the deal. And if you want, I will look, and I can find my notes of what the words were and the context. And you can decide what the significance of that is. But it'll take me a minute to do that.
I think you've answered the question. I get it that Agent Seacrest, you're testifying. It seems to me that it'd be fair to say that Agent Seacrest led you to believe that he was leading you on so he could get more testimony, get more statements from Mr. Bryan.
Certainly encouraging Roddy and I to believe that there would be a benefit to Roddy. But again, did he cross the line? I don't know, which is why I was going to suggest, if it's relevant, that I go find my notes as to exactly what transpired. But, I'm just a witness.
I think you've answered the question. If you feel you need to further explain your answer, you're certainly able to. But I think that it's clear on what your answer is. But
if I have the opportunity, I would like to.
Go ahead if you feel.
All right. Well, let's do this then, since we're going about.
Yeah.
Let's just go ahead and take a 10-minute recess.
Okay.
Just see counsel and,
For your honor.
If y'all get another. You didn't do the Hades.
No, Matt did the
I didn't
habeas.
hear it. No, I just didn't. I didn't hear it. I told him, when I saw it, I said, I will not raise 473 of those issues. I'm going to raise one issue out of the, whatever, 480 he raised. And it was a winner. The winner issue. And that is the emergency, but it's 60. So let's just stating the Hence the Lane case, you know, which I'm not going
we are back on. All defendants present, represented by counsel. Witnesses on the stand. Mr. Zell.
Thank you, Your Honor. All right. Back to where we were as far as you're holding your hands up, so if you have further explanation, go ahead.
Yes. I'm looking at some notes from the trial that look like they were notes prepared prior to whenever the Jackson v. Deno hearing was in the case. And I haven't reviewed the transcript from the trial, so I have no idea what's in there and what's not. It's 10,000 pages about. But my notes reflect my recollection that Agent Sechrest, somewhere on the first day, either before we started or on a recess, and I'm pretty sure there was at least one recess, that he did say to me that Roddy was not a target, but that GBI director and the DA were uncomfortable at that time saying so publicly. Now, to be fair, I can't say 3 years, 4 years later whether Mr. Sechrest was saying that the GBI felt that said that he was not, whether he was speaking for the agency itself or whether he was simply airing a personal opinion, to be fair. It did suggest that the GBI and the district attorney were in agreement with that, but he's saying that they were uncomfortable saying so publicly, and what that kind of means is that it's just not really there. And that's what I told Roddy. He didn't have any, there was no, what's the word for it? That statement wasn't going to mean a whole lot if the GBI decided to prosecute him. And separately from that, in the interview room, before the interview started, I expressed, and this would be May 11th, I expressed concern to Agent Sechrest about the statements being made in the media about Roddy, that mostly coming from the Arbery family, not from law enforcement, that Roddy was the devil or he was evil or a whole bunch of really unflattering things. And obviously they were very interested in Mr. Bryan being prosecuted. And Mr. Sechrest advised in the presence of Roddy that the mother, Wanda Cooper Jones, was reasonable and that they felt that they would be able to work with her. And obviously those are things that Roddy would have considered in whether or not to cooperate further. But again, I'm pretty confident that I told Roddy any number of times that we did not at any time have a deal, and that they were always subject to going in a different direction. Now, I have no idea how much of that came out. I do vaguely recall during the Jackson v. Deno or the discussion of his statement, Agent Sechrest made it best to sound like the GBI wasn't even interested in hearing from Roddy, that it was all defense counsel's idea or Roddy's idea. That was not true. I don't know that it matters, but those notes reflect my recollection of what actually happened. And so in response to your question earlier, that we were the ones insisting on the interview, I vaguely recall that might have been Agent Sechrest's presentation of that during that hearing, or that was the implication, but that wasn't an accurate rendition of what went on. The GBI very much wanted every piece of information that they could get from Mr. Bryan, and
Okay.
so
you, and just, I'm
Yeah.
sorry, did you finish your answer?
you had been. That was the issue. There was this idea that we were the ones pushing the GBI to talk to him. That's not a fair representation of what went down.
Okay, so, and when you say, just I'm going to circle back around to some of these matters you've raised now, but when you said 10,000, you're probably being very generous. It's up. So I get it that maybe some of this is not as fresh as the specifics, but what you just testified, you're referring to when Agent Seacrest at the Jackson Deno said you called him to arrange the interview. You're saying that's not true, that Agent Seacrest was lying.
What I'm saying is I can't recall exactly who called who or who texted who, but what I can tell you is that the tenor of that testimony, that it was Mr. Bryan and I desperately trying to fall over ourselves to help the GBI prosecute Mr. Bryan, that was not a fair representation. I'm not saying that he's lying, but that spin did not accurately reflect the situation. The GBI very much wanted his cooperation, and they wanted it then. They didn't want to wait. It was the GBI who was insisting on getting this process done. Either Roddy was going to speak to them or he wasn't. And it wasn't me rushing to have an interview on May 13th. I was trying to find a way to put it off, and in fact, if I recall correctly, I can go look for it, I emailed the Justice Department, that's the U.S. Justice Department, trying to get their help in putting that interview back.
Okay. So just for
I don't need to find it. I wasn't rushing in on May 13th. I would have taken as much time as we could get, and it just wasn't an option.
So just for the record, Mr. Dukowski, for your honor, that reference I referred to with Agent Seacrest was the 1 year anniversary of that second interview, Volume 1, May 13, 2021, page 128, when that was arose. You're speaking of the Jackson Deno hearing, when the agent testified about that. Okay. All right. So now, and circling back again to something else, was that you said down here. That was before the break, and I hadn't had a chance to, we took a break before I had a chance to follow up on that. Down here, you said it sounded that you were talking about, you had, I don't want to say deals, but understandings with maybe the law enforcement as opposed to the prosecution office. Is that what you're referring to?
Non-deal deals is a prosecutorial / law enforcement practice of working out arrangements to get the cooperation of witnesses without having to own it. Now, you can do that unethically. You can have the DA and the defense lawyer sit in a room somewhere, wink, wink, nod, nod, we're not going to tell anybody. That's a non-deal deal, I suppose. More often, there is no deal. It's contextually. Other times, it works through law enforcement. It's a thing. It's highly unethical. It's unethical for prosecutors, and it's unethical for defense lawyers to have a deal in place and not disclose it. At least for the prosecution, it would be considered a violation if they called the witness to testify. But these things happen. And sometimes, Mr. Zell, you're a criminal defense lawyer, sometimes you have to cooperate without having even a non-deal deal. You just have to do, quote-unquote, the right thing and hope for the best. Sometimes that is the option that is presented to you. And what I'm trying to tell you is that Agent Seacrest walked that fine line between having a deal and not having a deal. And I can't say sitting here that he crossed it. A deal has to be approved by the prosecutor. And it was abundantly clear that the prosecutor was not involved in that discussion. That was basically Mr. Bryan speaking to them, hoping for the best. And he was aware of that. And there were subsequent discussions about that in the car, riding around when the reenactment video or the path of travel video is made. And then Mr. Bryan was still concerned, as I was, all through the process, that they could turn around and arrest him. And in fact, he turned around and made some comment about it, and the officers, I can't say Officer Seacrest was laughing, but I mean, the one or both of, I can't remember if there was one or two officers in the back of the car, but it was almost like a joke, because they're trying to reassure Mr. Bryan that they're not going to prosecute him. But again, they haven't promised not to prosecute him. We have no agreement that he won't be prosecuted.
And Mr. Bryan is aware at all stages of this, that there's no such agreement in place, and they can still turn around and prosecute him. But obviously when he's sitting there going through the path of travel or the reenactment, however you want to describe it, he's certainly hoping he's not going to be prosecuted.
And it would be fair to say that once, if one of these, I think you said Mr. Bryan asked that maybe multiple times, are you going to arrest me, are you going to prosecute me?
He made comments. He didn't come out and directly ask the question, but he made comments expressing concern about that. He was very, very worried about being arrested. He had just bought a home, and if he got arrested, he was going to lose the home, and they did lose the home very quickly. I think it might have been a deed in lieu of foreclosure or whatever it was, but they lost the home very quickly. That was a hard thing for him to get. So he did not want to be arrested. And, you know, that was a fine line that Agency Chris was walking. We were in the middle of a public relations storm. This case generated publicity such as I don't think I've ever seen before. I think there's a reference in one of the motions filed to the internet activity for this case, I think, dwarfed the O.J. trial, which I didn't think was possible, other than the expansion of news media. But Roddy was very much concerned about his life, and there was a death threat, I think, in the mailbox. And some of this may have been covered in the Jackson v. Deno hearing. I don't recall. There was a death threat or a letter in the mailbox that was turned over to the GBI. There was a news crew in the neighborhood the day that video was being made, and the media had left because shots had been fired or there was a report of shots fired. There had been a rather uncontrolled parade through the neighborhood by those concerned about the tragic death of Mr. Arbery. They had Mr. Bryan had driven to Atlanta for the polygraph examination. Savannah for the polygraph examination, and reported, he and his wife reported that they had been run off the road or felt they had been run off the road. They were literally scared to death at the time, and they were being tried in the media at that time. And that was just egging on this hatred, public hatred for Mr. Bryan.
Certainly, if any of these times when Mr. Bryan expressed this concern about being arrested, had he actually been arrested?
No, Mr. Bryan wasn't actually arrested.
No, that's not. Had he been arrested, the interviewing would have stopped. You would not have continued on with any interview. Is that correct?
Oh, no. If he had been arrested, that would have been the end of that process. Yeah, okay. At least, at that time. You never know what's going to happen down the road.
And then the last thing I want to circle back to is that you had, when you testified when we first came back from the break, that if the GBI decided to prosecute him, in fact, the GBI doesn't prosecute, it's the district attorney's office that prosecutes, right?
Technically,
yeah.
The district attorney's office makes a decision. But Vic Reynolds was, if I recall, the former district attorney in Cobb County, and that and the fact that he was director of the GBI, I imagine he had some say-so in the prosecution. And who was prosecuted, I don't know. I wasn't there. But I do know that our dealings were mostly with the GBI. We had very little contact with counsel. We couldn't get it, and my recollection was that Mr. Agent Seacrest was supposed to come and see me at the St. Simons Island Starbucks after they had finished up speaking with Roddy on the 13th and doing the other things they were supposed to do. And I don't have the text in front of me, but either he wasn't coming, his superiors wouldn't let him come, I forget what the explanation was. And that was the end of that.
And then Mr. Bryan was arrested on May the 21st, about roughly 8 days, a week later, after the second interview?
Yes. The GBI, I can't remember if they texted me or they emailed me, but they let me know that they wanted him to turn himself in, and we arranged for him to do that. That was what we agreed to do if they decided they were going to pursue it. I certainly didn't want them coming in the middle of the night with the SWAT team to come get him.
Okay. And I'm going to move on to the second issue now, the mistake of fact issue.
Yeah.
And just ask you about that. Is that something that you had considered during your preparation for the trial? Or what I'm really getting at is, when did you first consider that as a potential defense or jury charge or argument that you could make in this case?
Are we talking about mistake of fact?
Yes, mistake of fact, yes.
I can't remember when it first came up. My recollection is that either Bob Rubin or Jason Sheffield had come across something, for just happenstance, came across something about mistake of fact, and they had sent that to me, and I mean, I was already aware of the concept, but they had sent me, it was interesting, and one thing led to another, and that led to the jury charge that was submitted, which was, it started out as part of a citizen arrest charge, which started out as a brief or a memo on that, and there was good faith defense and mistake that were weaved together as part of the larger charge. The judge said no. We came back and we submitted good faith defense and mistake of fact, the charge we wanted, separately, and the judge said no. And Ms. Dunikowski had said she was okay with the pattern charge, which was not really what I wanted, but we take what we can get. And so my intention was to argue mistake of fact at the trial.
Did you, in fact, prepare that in your closing arguments before you made the argument to argue the mistake of fact?
Yes. The closing argument, which I did actually skim through last night, is about 140 pages, I think, of transcript. I was the last counsel to give a closing. Well, next to last. I think Ms. Dunikowski opened and closed. I was last defense counsel, and this was hours into the presentations of the day. But I had a series of notes. I had typewritten notes. I had handwritten notes, and I had notes to say something that I hadn't written out, just to come up with it. And I included the mistake of fact pattern charge, and my intent was to argue, and I had it, basically I took the charge I submitted and didn't get, which was more helpful, and what I was going to tell the jury what this means is, and get it in for what I could that way, and then expound upon that. As the closing arguments went forward and issues were covered or not covered in different ways, I adjusted the order of presentation and the arguments that day as we were sitting here. And somehow in that process, the mistake of fact argument, such as it was not given. And I believe I let Mr. Bryan know. I can't remember when I let him know, but at some point I let him know that, I had figured out that had not taken place, and that was not a strategic decision, that was simply an error, a blunder on my part. And for that, I apologize. I apologize to Mr. Bryan then, and I feel bad about it to this day.
Regarding, you mentioned the good faith, and it's something that you had requested, but that, in fact, was denied. Is that your request was denied?
It was.
Okay. And so Judge Walmsley actually did not instruct the jury on that particular point of law?
I believe he declined to instruct the jury on it. I argued it anyway, as best I could. And I'm thinking that I probably would have addressed the mistake of fact. Originally, I probably would have addressed it right after the good faith defense. And I don't know why that didn't happen.
And the mistake of fact was something that Judge Walmsley actually granted at the request of actually Mr. Domkowski, right?
He gave us the charge. It wasn't the charge I wanted. It did really, it had limited, the pattern charge on mistake of fact had limited utility in my judgment, but I went with what I had, or I intended to. But that argument was, it's just not there.
In your practice, since you didn't do it in this case, when you do obtain a jury charge on some defense, an affirmative defense or a quasi-affirmative defense, like, I don't want to say quasi, but a quasi, like one like alibi or something, is that something that you normally would argue if the judge is going to instruct on it?
I can't say that. A lot of times as defense lawyers, we request charges that we have to request, but we don't really anticipate getting much mileage out of. There are other times when we request charges and we're just going to throw them out there hoping that a jury, the way I would describe it is squirrels. You got a juror just going off on a tangent that no one ever thought of. The more charges you discuss and the more stuff that's in the charge, the more likely it is the jury will go in an unanticipated direction. And sometimes it turns out they're pretty good directions. Sometimes not. But in this particular case, it was my intention to review the jury charge on mistake of fact, to discuss the charge I wanted without calling it a charge, because that wouldn't have gone very far, and then to elaborate on that. Now, to be fair, as I sit here today, I can't recall what the exact mistake of fact was that defense in the charges the court gave it would have hinged upon. But that's been 3 years. I had a plan then, and I just, but all I can tell you is that was not a strategic choice. That was an oversight. And it doesn't matter that there's 140 pages of other arguments. It should have been presented.
80 pages, but
I'm sorry?
80 pages.
80 pages? I'm sorry. I thought it was longer than that.
Unless my math is bad.
It was an hour and 40 minutes.
94:47 and 95:27 is what I have in my notes. But okay. But in any event, the last thing I want to ask you about, though, is aside from this, just Mr. Bryan himself. Did you obviously got to know him during the time of your representation? That would be fair to say.
Very well.
Okay. Did you know his educational background?
I did.
And what is his educational background?
Minimal.
Okay. And when you say minimal, I mean minimal to somebody who's a PhD in physics.
He may have graduated from high school. I don't recall sitting here today, but he was certainly not a academically inclined gentleman. He is more of a hands-on kind of guy. If you ask him to do something with his hands, he's very capable and he can do it. But he's just not a very good, he's not a very articulate speaker, and he gets frustrated when he can't find the right words to say what he wants to say. And really, more than anything else, his lack of verbal skill really hurt him on the day of the shooting and in the interview that followed, because he really needed a lawyer. And had he had a lawyer before he made those statements to the police, I don't think he'd be here today.
Would it be fair to say he has no legal education, no legal training?
No, he doesn't.
And
he had certainly had difficulty following some of the legal concepts in this case. I think it was Bob Rubin had said at some point, the Arbery, I still call it the Arbery trial. I don't mean to offend anybody by that. But it's like a law school exam question, a never-ending series of law school exam questions. And certainly it was difficult for Mr. Bryan to keep up with many of the nuances of the trial, of the case, and the legal concepts.
did you notice these issues or part of these issues when you first began representing Mr. Bryan?
Yes, it was obvious that he had a limited education. Matter of fact, I still get grief about talking about that.
It's no disrespect from either one of us. It's just a question I have to ask.
Yeah. I mean, he was of limited intellect. I mean, he's not retarded, but I think he did struggle in school learning. I can't remember the details, but he was never a good student. He's just a quiet guy. I mean, the crazy thing about this whole case is his conduct on that day is just completely the opposite of everything he is and everything he's been in his whole life. I mean, really, it was 2 minutes of bad judgment in an otherwise remarkable life.
So just the last question. In the conversations you had with him when prior to May 8th when he retained you and after and prior to his May 11th interview, this was abundantly clear that he had his communications were limited, or perhaps he was not the best communicator.
I think it was clear even by May 11th that his verbal, even in those 3 days, that his verbal skills were limited. I think it was an issue. Again, it's been a while, but I'm pretty sure that we took a break on May 11th during that interview, and Agent Seacrest and I went outside and spoke. Roddy was really nervous, and if I recall correctly, he was struggling a little bit, and Agent Seacrest, I think, was getting a little bit frustrated. And we took a break, and Roddy settled down, and we went forward. But yeah, it was clear that he was not the most verbal. I think, and maybe that wasn't clear earlier. I mean, we were in a public relations war in the first early part of this thing, where people were talking about killing Mr. Bryan, trying to present him in a better light, and I think I ended up on an exchange on national television with, I think it was Chris Cuomo, because he was going outside the parameters that had been set, because any time Roddy spoke about this case, and there were really only a handful, but any time he spoke, that was all carefully controlled. And Mr. Cuomo didn't believe in following those understandings, and I had to step in because I didn't feel that Roddy needed to be subjecting himself to a cross-examination by, of all people, Chris Cuomo, who's a very capable journalist. And there were risks in Roddy speaking to Agent Seacrest. There were huge risks. There were risks that we didn't know exactly what he said on the side of the road. We didn't know exactly what he said when he went to the police station. And he had some memory, but we all know those memories. We remember things the way we want to sometimes. I was aware of his limited ability. But frankly, in some ways, as a result of having given those interviews, Roddy Bryan did not need to testify at trial, which he was, by the time we got to the end of the trial, he was just petrified, scared to death. Witnesses got up here, prosecution and defense, and just got blasted from all kinds of angles from things they had no idea were coming. And watching how the police officers got cross-examined and some of the civilians got cross-examined, it was scary. So, the fact that Roddy was able to put that version out there in some ways made it easier for him not to testify. It reduced what we were losing by not testifying. The version's not the right word for it. The statements that Roddy gave on May 11th and May 13th were much, much improved over the statements that he gave to the police when he really didn't know what was going on and he didn't know what his rights were. And in retrospect, I agree with you, Mr. Zell. That was it. That was a gamble in cooperating with the GBI. It was a gamble based on limited information. But in retrospect, that was the right call. It was the right call because, among other reasons, Roddy didn't have to testify. And it presented him in a much better light than he presented himself, certainly on the side of the road, with that, and I don't mean any disrespect to the co-defendants, but that Greg McMichael, former law enforcement bravado. And I felt like Roddy absorbed some of that when he was out there and later. And when he came back and spoke to the GBI in May, his statements were more thought out. And I think, in retrospect, I don't regret Mr. Bryan cooperating with the GBI for a moment. It was the right decision then, and it was the right decision now.
Okay. That's all I have. I appreciate your testimony. Thank you.
Anything from the state?
Yes, Judge. All right, Mr. Goff, where'd you go to law school?
The University of Georgia,
Where'd you go undergrad?
College of William and Mary.
And so basically you've spent your entire life practicing criminal law.
Yes. Well, since 1987.
1987. And you know that as a former assistant district attorney, it's the district attorney's office that brings the indictment and the charges.
Indeed.
All right, so let's go ahead and talk about the timeline briefly. You recall that on May 5th of 2020, Scott Ryfin was given the copy of the homicide video and released it to the public.
Yes.
Okay. And that is basically the day that kind of the media firestorm started, because now the public had access to actual evidence from this case.
Yes.
So at that point, Tom Durden was the district attorney pro tempore, and he called the GBI in to go ahead and investigate. Do you recall that?
Yes.
All right. So when the GBI is called in, Special Agent Dial comes in, and the McMichaels are arrested on the evening of May 7th, 2020. Does that sound right?
Yes.
And so you were then hired, because we have your fee check, from May 8th of 2020.
Yes.
Okay. So were you aware of the McMichaels being arrested?
Yes.
Okay. And so when Mr. Bryan came to you, he came to you seeking legal advice.
Yes.
And wanted you to do what?
To represent him. To represent him, and I treated it as pre-arrest representation. The hope was he might not be arrested. And frankly, Mr. Bryan certainly did not have the money to hire anyone at that point to represent him. A full fee in a murder case. He just didn't. So it was pre-arrest representation only. It was $2,500 retainer for hourly, on an hourly basis.
All right, so you're representing him pre-arrest, and the goal is to hopefully keep him from being arrested for murder.
Yes.
All right. And when you met with him on May 8th, did you then try and obtain as much information about what was going on with the case as you could?
I tried to obtain what information I could. I was limited in my ability to do that. Other than the media and Mr. Ryfin, there were no discovery rights at that time, and the information I had was limited and largely from Mr. Bryan.
Okay. And so Mr. Bryan, of course, is trying to recall what he said at approximately 1:14 on February 23rd, 2020, and what he said 3 hours later at the Glenn County Police Station, and telling this to you on May 8th.
Yes.
But he's doing it. He's giving you that information that he recalls.
Yes.
Okay. So you knew he had made statements at the scene.
Yes.
You knew he had talked to the police.
Yes.
You knew he'd handed over voluntarily his cell phone, and they had downloaded the homicide video.
Yes. Well, I knew they had tried to download it. I'm not sure when I found out that there were questions as to how successful it was.
Okay. And then you knew that he had taken his truck back over to the Glenn County Police Department and had them forensically examine it for fibers and fingerprints.
Yes.
Okay. And that he'd also given a recorded 1 hour long interview to the lead detective at the Glenn County Police Department approximately 3 to 4 hours after the homicide.
Yes.
And he was able to tell you what he recalled about the facts of the case, meaning his actions.
Yes.
Okay. And so we have May 8th, we go into May 11th. Now, I don't know if you'll recall specifically, but on May 11th, that very day, when you had the interview with Seacrest, District Attorney Pro Tempore Tom Durden recused himself. Do you recall that?
I know he recused himself. I don't recall the exact day, but as I testified earlier, there was a lot of stuff going on, and explanations for why district attorneys were not available were semi-plausible.
Okay. So that evening, May 11th, 2020, Joyette Holmes of the Cobb County District Attorney's Office was then appointed as District Attorney Pro Tempore. Do you recall that?
Yes.
Okay. And during this time, May 8th through May 11th, were you trying to reach out, meaning call Tom Durden and speak to him about your client?
I believe I made multiple attempts to reach out to the prosecution.
Okay.
But I can't recall the details.
Okay. Do you recall multiple attempts to contact Joyette Holmes in Cobb County?
I'm pretty sure there was more than one.
But in the meantime, we've got the GBI via Special Agent Seacrest desiring an interview with your client.
Yes.
And so when Mr. Bryan actually met with you on May 8th, did he tell you that the GBI had already reached out to him, or was this something that happened after he hired you?
No. My recollection is that the urgency of hiring me was that the GBI wanted to speak with him.
Okay, because the GBI had been brought into the case on May 5th. McMichaels had been arrested the evening of May 7th. So here we are. Of course, the GBI is on the case. They're making phone calls to Mr. Bryan saying, we want to interview you.
Yes.
All right. And did you discuss with Mr. Bryan what a GBI interview would be like?
Yeah. Yes, I did.
Okay. And you went over the pros and cons of doing that interview.
Many times. Look. We reevaluated whether or not cooperating with the GBI in making a statement. That was a huge question that was constantly being reassessed the whole time.
And in fact, when the first interview took place, I believe at the beginning of that interview, you remind Agent Seacrest that you and Mr. Bryan have placed limits on that interview. You're not going to talk about the homicide itself. You're only talking about what took place afterwards. Do you recall that? Okay. And those were your limits and Mr. Bryan's limits in order to get comfortable with Agent Seacrest?
First, to get comfortable, but also to limit the liability, the downside of the interview. When Mr. Bryan is talking about conduct after the shooting forward, which in retrospect seems odd, but there was a lot of controversy around the video at the time, including its authenticity and where it came from, and that was the heart of the GBI's case, and they needed Mr. Bryan's cooperation to get that. It didn't have to have it, but it would make it easier.
And when you mentioned that there were things, meaning other information that you could offer the GBI, you mentioned his night owl video,
yes,
which unfortunately the Glenn County Police Department had never asked him about or obtained, but he revealed, I have this video, and at that point Special Agent Lawrence Kelly was able to go retrieve the night owl video from Mr. Bryan's home service.
I think that actually happened on the 13th, but I could be wrong.
I think you're right, it was on the 13th. So, but that's some of the things that you were willing to do to show cooperation?
Show good faith, anyway. It's important to remember that the goal at this point was that the GBI recognized Mr. Bryan publicly as a witness rather than a target of their investigation, to kind of take that target off his back, not just in terms of law enforcement, but in terms of being killed before this case could go to trial. So that was important, and he had been very helpful, whether he intended to or not, by making the video on the day of the shooting, and he had been pretty cooperative that day on the side of the road. And at the police station, for better or for worse, he made the decision to cooperate with the police before he had counsel. And a lot of what complicated his situation was because he'd already made that decision and started down that road. Does he want to continue down that road or go the other way? He did have information like the Night Owl video, and there were a couple other items of evidence or testimony that the police did not have. There were some statements that Mr. Bryan overheard Greg and or Travis make in the aftermath of the shooting that were not on the video that he made that the police wouldn't have in any other way.
In addition, was Mr. Bryan able to then reveal how Greg McMichael obtained the video from his cell phone in order to hand it over to the media?
I don't recall the details, but yes, there were things that GBI wanted from Mr. Bryan, and the idea that Mr. Bryan is knocking down the door of the GBI office to volunteer information is a bit of an overstatement. But he'd already made the decision to cooperate on the day of the shooting, and that had a big impact on how to go forward because he had already made statements, and there was no taking them back.
So the goal with these interviews, because the GBIs requested the interviews, your choice then was to not participate or to continue to cooperate. And the choice to continue to cooperate, is it fair to say that's the hope that he never is arrested and then becomes a witness for the GBI and or the prosecution?
Right. When we talk about deals, there was never a discussion of a plea. It was a discussion of being prosecuted or not. There was never a notion of immunity at that time because it was not. It just not something that was realistic at that stage. No prosecutor in America, much less your office, is going to grant immunity in a case that high profile when there's so many loose ends out there. The goal was to be a subject rather than a target and a witness rather than a defendant.
So I just want to be kind of clear about this. And I know it's been 3 years. So if you recall, I think you did file a Jackson-Deno motion. We never had the Jackson-Deno hearing because he was represented by counsel and was not under arrest at the time of Agent Seacrest. So would it be fair to say that your memory of this interaction and cross-examination of Seacrest was actually during trial?
It may have been during the trial.
Okay. And do you remember you cross-examined him for a couple hours during trial?
I'm sure that I had more than a few questions for Agent Seacrest.
Okay. All right. So when we talk about doing the second interview on the 13th, May 13th, I believe, you correct me if I'm wrong, that when you met first with Agent Seacrest, you set the parameters of Mr. Bryan is going to talk to you only about what took place afterward. And if we're comfortable, meaning if we trust you and Mr. Bryan's comfortable with going forward, he makes that decision, then we'll do a second interview. Was that done to kind of show good faith on Mr. Bryan's part and to hopefully keep the GBI strung along?
Well, the first interview certainly was to show good faith. Among other things, the GBI had to assess whether Ronnie would be useful as a witness, and early on there were some questions as to, some people just aren't good witnesses. It's got nothing to do with what they know. It's got nothing to do with the truth. It's just got to do with the the personality of the person. And now I forgot the rest of what you asked me.
Was it also an attempt to maybe string the GBI along to buy more time and forestall potentially what could happen, which would be an arrest?
Well, certainly. Buying time was important. We were well behind the game. The GBI had, I can't even remember how many agents were down here, and you had just a lot of activity going on. So, yeah, we needed more time. I would have wanted more time. I did everything I could think of to buy more time. But ultimately a decision had to be made whether to go back and on the 13th or not.
And did you discuss with Mr. Bryan his decision to go ahead and go forward with that second interview?
Yes.
And did you also discuss the fact that you were going to talk about what actually happened at the homicide at that time?
Yes.
I think you previously testified that you were there to do the right thing and hope for the best. And because at that point, the prosecutors were not involved in any decision. And so what you were hoping for was, I'm going to let you finish my sentence for me.
That Roddy would be identified as a subject, not a target, as a witness, not a defendant. That's the best. It's the best we were going to get under the circumstances.
And he voluntarily turned himself in.
He did.
And at that point in time, you were retained to go ahead and represent him at trial.
Yes.
Okay. And I'm not going to belabor the entire trial experience, but you filed numerous motions, is that correct?
Oh, yes.
Okay.
Yes.
And you filed motions to recuse the district attorney's office, along with discovery motions, and you received the discovery packet, is that correct?
Yes.
And reviewed all of that evidence.
Yes.
And prepared cross-examination of the witnesses.
Yes.
And talked to Mr. O'Brien about his decision to either testify or not testify.
Yes.
Okay. And I take it that you felt, and correct me if I'm wrong, but that because he had made the statements to the GBI and had gotten his sort of softer version of the events that took place on February 23rd, 2020, that your advice to him, but it was his decision, might have been to not testify since he didn't necessarily need to, given his statements were already in evidence.
That's correct.
Okay. But it's not your job to tell him what to do or not, right?
It's not my job to tell him, and it was emphatically clear that he did not want to testify at that time, after watching the way witnesses were treated during the trial.
And so when you talked about the fact that you knew it was a risk to go and be interviewed, have Mr. Bryan interviewed by the GBI, it was a strategic decision to go ahead and embrace that risk with the hope that he'd be identified as a subject and not a target and not arrested.
Yes, that was a calculated risk.
All right, let's go ahead and move on to the mistake of fact jury charge.
Okay.
All right, so the state, me, wanted the pattern jury charge. Is that correct?
You always want the pattern jury charge. Every prosecutor does.
We all do. So in this case, the trial court did give the jury the pattern jury charge of mistake of fact for them to consider.
The court did.
All right. And they had a copy of that jury charge back with them. Is that correct?
Yes.
Okay. Now, I get that you had previously, or you just testified, that it was not a strategic decision to leave out the mistake of fact argument, but a blunder on your part. But I want to kind of talk to you about what took place that day. The state gave an hour-long opening, closing argument, and then the McMichaels gave, not the McMichaels, Travis McMichaels' counsel gave the closing argument, and then Laura Hogue gave Greg McMichaels' closing argument, and then we got to about 3 o'clock in the afternoon, and it was your turn. Does that sound fair? And you gave an hour and 40-minute long closing argument.
Yeah, I think co-counsel were a little disappointed. Well, I think the hope was that the defense closings, and I had help along the way. I wasn't the only person that took some time, but I think the hope was that the defense closings would finish in time to force you to give your closing the same day and not get the benefit of the evening to parse through everything that had gone on during the day. Aside from going last, it's a considerable advantage for the prosecution when you can get a recess overnight. And it's unfortunate. On the other hand, I'm not sure how much time I could have taken where you wouldn't have gotten the evening anyway.
And you had a lot to cover with regard to Mr. Bryan, as far as a lot of the legal issues.
In some ways, Mr. Bryan had more legal issues than the other defendants.
And of course, they hadn't covered them yet.
Well, no.
Okay. So with the McMichaels closing arguments, they basically had to cover citizen's arrest, self-defense, and what took place that day, as well as reiterate Travis's trial testimony. Be fair to say?
Yes.
But you had to do something different because your client was in a different position.
He was in a very different position.
Okay. And that was your argument, that he had no knowledge that Travis had the shotgun.
That's correct.
Okay. And I believe at the very end you wrapped up by saying, when would Mr. Bryan have been able to stop this from happening?
Yes.
Okay. Now, I think you testified that as of right now, when you sit here 3 years later, you can't really recall what the mistake of fact would have been. But you're very, very smart, Mr. Goff, and you're a very, very good attorney. I mean, right now, what would have been the mistake of fact argument under these facts?
I'm sure it would have been very good, but to be fair, I can't recall exactly what it would have been because that part was not written down. There were several parts of the closing that were not written down. Just run out of time and you say something about this, say something about that. To be fair, going back through the motions, there's some motions I filed looking back today. There was a reason for them at the time, but, it takes some time to piece it together. But I can't identify for you what that fact would be.
All right, so I'm just going to throw this out there. When we look at the jury charge of mistake of fact, it's an affirmative defense, correct?
It is.
And it's an affirmative defense where basically the defendant is charged with a crime but says, I'm not guilty, I didn't have any intent to commit this crime because I had facts that, if true, would have enabled me to go ahead and do what I did. I'll give you an example. If I have my friend Cindy tell me that my friend Leslie is allowing me to use her credit card and I go to the store and buy a whole bunch of stuff, am I intending to steal from Leslie because I'm using her credit card? Well, I'm operating under the mistake of fact that my friend Cindy has told me, oh, Leslie's okay with you using the credit card. And that's my defense. No intent to commit theft. I was under a mistake of fact because I was given information by someone else, correct?
Yes.
Okay. Did we have anything that resembled that in this case?
Well, Mr. Zell won't tell me, but he obviously feels he's got a pretty good one. But he doesn't have to share it with me. Mistake of fact is a problematic defense because it depends on the underlying offenses. Some offenses lend themselves more to it than others. But, again, I did not consciously make a decision not to present that. As you can see from what was presented, I did deliberately leave out small snippets here and there. As the trial went along, they weren't as important. But mistake of fact is something that should have been argued, and it'll be for you and Mr. Zell and Judge Walmsley and the appellate courts to figure out what to do about that. But I'm not sure what more I can tell you.
I guess that's where I have a problem, is that you say it should have been argued. But if right at this point in time, no one can say how it should have been argued or what context it would have been argued in, because you'd agree that the state, in its first closing argument, got up and actually said, this case is all about assumptions and driveway decisions. And we all know you can't make an assumption and then claim mistake of fact. So are you certain you didn't pivot and go, I'm not going to argue that, given the state just got up here and argued that my client made an assumption? If I say mistake of fact, I'm actually saying his mistake of fact is an assumption, which would have played right into my closing argument?
My recollection, 3 years later, is that that was simply a mistake. For example, sometimes jurors will do what I call squirrel. That's a phrase we used to use in the debate world when I was a college student, where the judge would just go off on something that nobody realized was important. So a lot of times, even if you're not impressed, you're going to at least present the charge to the jury, argue the charge to the jury, say something in the hope that one of the jurors will see something in it that different than you saw or that you saw but couldn't say. But when you don't discuss the charge, that alone is harmful because you get back in the jury box, particularly in a case like this where the jurors have First Amendment rights, and all these jurors probably assume that somebody's going to spill the beans, when the whole thing is over. Who wants to be the juror in this case in the back of the room arguing the mistake of fact that the judge charged to the jury when somebody else in the jury is going to say, the lawyer didn't even mention it. If the lawyer didn't think it was important, how important could it be? So there is a harm in not covering a charge that actually has potential value. Does that mean that a jury would have found a mistake of fact if I had argued, if I had spent an hour on it? I don't know. But it should have presented it.
Well, in Mr. Zell's motion, he claims it was your sole defense.
Well, that's ridiculous.
Tell us why.
I can't even count the number of defenses that were put out there. And I'm not even sure mistake of fact would be the best of the defenses that were available. Part of Roddy's problem in this case was that the citizen arrest law, of course, the citizen arrest law that got to the jury was much different than the one that I learned about. That's a different issue. But putting that issue aside, the law of citizen's arrest for over 100 years is extremely harsh. I mean, that's not what I would have argued at the time of the trial, but the reality is that citizen arrest law is brutal. Even the old citizen arrest law. I mean, if you help somebody arrest somebody, you better be right.
I'm sorry, I don't mean to object. Maybe I should say you just misstated what I wrote. I did not say it was a sole defense. Maybe that alters your question. I said the only viable defense. I do think that's a difference. At least it is in my mind.
Thank you, Mr. Zell. Thank you, because in my mind, I read it as sole defense, but I will go ahead and then. So, was it the only viable defense?
Well, jury nullification is always a delicate subject. And a lot of the problem with this case is that in Georgia, what lawyers can say with respect to jury nullification is extremely limited. There's snippets in the pattern charge that you can throw out there. Nobody can tell a jury that they have the right to acquit for any reason or no reason at all. Nobody can tell them that. The judge can't tell them that. The lawyers can't tell them that. But they can reach that conclusion on their own, and there are snippets in the charges. But the more directly you approach that argument, the more you risk someone coming down very harshly upon you from the bench. So it gets very difficult. But in Roddy's case, under the law, if the McMichaels didn't have probable cause, I don't know whether Roddy can have probable cause. Certainly sitting here 3 years later, I don't know the answer, but I do know that Roddy was a very sympathetic defendant. And the jury had the opportunity, if they chose to do that, to agree that he was just a dummy in the wrong place at the wrong time, and that a few short minutes of bad judgment in his life, completely acharacteristic, uncharacteristic, the opposite of his entire life, should destroy it. The jury could have, regardless of the charges, let Mr. Bryan go, which is why the jury selection process was so important in this case. We lost the case of jury selection. We didn't lose it during the course of the trial with you.
But you made those arguments in your closing, didn't you?
I came up with every way that I could think of under the law, consistent with the charge of the court, and my duty as an officer of the court, to get someone, at least one person on the jury, to give Mr. Bryan the benefit of the doubt. I argued it every different which way I could. But what I didn't do is I didn't argue mistake of fact. And I can't get around that. Whether that is harmful error or not, whether that meets the second prong of Strickland or not, I don't know. But I do know what I didn't do. And I will defend, I don't, as an officer of the court, I will defend what I do when it's right. But if I've made a mistake, and there are some mistakes that are just open and obvious, and if you had a charge you intended to argue, and a defense that you intended to argue and you didn't, your duty is to say so. It's not my duty to figure out whether that matters or not. That's between you and Mr. Zell. But that was not a strategic decision. And if I had it to do over again, I don't know whether I would have put a special colored paper clip on it or what, because that closing had, a couple inches worth of materials to work from, and it was unfortunate that it got misplaced.
And the jury came back not guilty on several charges, didn't they?
Yes, and they probably felt that they were doing Mr. Bryan a big favor because he really didn't understand the law, particularly the law of felony murder. But I have no doubt that when they were back there, they thought they had cut Mr. Bryan a significant break. I doubt that any of them appreciated that he was going to receive a mandatory life sentence as a result. But under Georgia law, we are not allowed to discuss sentencing in front of the jury. And I have no doubt that if there had been any explicit attempt to address that subject, however indirectly, that would have been shut down in a heartbeat.
Indeed. If I may have one moment, Your Honor. I will pass the witness. Thank you, Judge.
Mr. Zell, any redirect?
No further questions, especially since Mr. Mikowski was the one in the charge conference who asked for the charge and said he has every right to argue it. I'm surprised he didn't ask for it. So, no, I have no more questions.
Okay. Thank you, Mr. Scully. You may step down.
If I may inquire, Your Honor, some other advocates in the case, am I excused or should I go back to the witness?
Is he under subpoena?
Yes, he is, Your Honor.
Okay. Is he released or does he need to remain?
We probably need to call him as a witness, and, excuse me,
It's okay. I think that answers the question.
I'm
sorry.
outside today. I'll be outside.
Okay. Thank you, Mr. Scully. All right. It's probably a good time to take a break for lunch. So let's go ahead and take an hour. It is 1:24. Let's plan on reconvening at 2:30. And court's in recess. Thank you, everybody. right, we are back on. Defendants present, represented by counsel. Mr. Johnson at the lectern.
Yes, Your Honor.
Yes. I do need to make sure, Mr. Zell, I've taken evidence on your motion.
Is complete.
All right.
There's the rest of our evidence.
All right, thank you.
That was my understanding.
All right.
Before we start, I don't want to belabor points I go ahead. Sometimes I'm a little dense. My purpose is to complete my proffer on the transcript from the 3 jurors that we have under subpoena. And we've put them on 30-minute notice, and we've called them to be here. One says she won't be, and I don't want to belabor that, other than if we do call her and she's not here, then that's just going to be that. My purpose is to put Mr. Wilson on the witness stand. He's the investigator. Have him describe what he does and the circumstances of taking the recording, listening to that he's compared the recording to the transcripts, and they are accurate transcripts. And if I understand the court's ruling, and that's why I'm wanting clarification, if I understand the court's ruling, you're not going to accept testimony from the jurors, and you're not going to accept the proffer of these transcripts. I don't know if I have that right. Secondly, I want to address filing things following today's hearing. For example, and I do move to file it under seal, and I'll move to file these transcripts under seal. But I will want to refile the notice. We filed the notice without exhibits. I'm going to want to file it with exhibits, and I'll move to file them under seal. I just wanted to clear that air, and if I'm wrong someplace, I don't want to run afoul of the court's ruling.
First, the court hasn't said that you cannot call any witnesses. The court has ruled on objections based upon what I understood to be effectively the proffer. So the challenge with this is we're now re-plowing the ground. So there was a notice of intent that was filed that contained excerpts from these transcripts.
Yes, Your Honor.
Okay. And that's why I said earlier, I assume that those excerpts are the most material of the statements.
There are some other material things, but yes, they're the gist of what I want to accomplish.
So understanding what the intent was with regard to those witnesses, I have ruled on what the court will and will not permit as far as evidence here. If you wish to submit those transcripts, and what you're suggesting is you're going to do that in order to perfect the record.
Yes, Your Honor.
Ms. Donakowski, any objection? I mean, that appears to be the way this is going, and the way I understand that is going to be submitted with a motion to put those under seal.
I believe it would be appropriate under seal because it's the whole interview, and there's material in there that I'm sure the court would rule inadmissible, and there's material that we believe is admissible.
Okay, let's do one step at a time.
I'm sorry, I apologize.
Perfecting the record on the transcripts from the state.
Thank you, Judge. The state does object, and there are several bases for this objection. Number one, the investigator went out and interviewed 3 jurors and recorded it, and we have these transcripts. But that doesn't mean it's not hearsay. And the problem is, if it's being proffered at this point in time to claim that you were in error by not allowing evidence for Rule 606, I still have a problem with it because it's not an affidavit and it isn't necessarily live testimony. Because if we analogize it to something like a gang expert, and the court rules that the gang expert, because it's not a gang case, is not allowed to testify, the defense would still say, I want to proffer what my expert would testify. Usually that proffer is done by the attorney who stands up and says, I anticipate my expert's testimony to be these things, and then there's a ruling on that. Some attorneys actually want to put the witness on the stand to go ahead and give the anticipated testimony so that the court can see its relevance to the issue. But in this particular instance, it appears that these would be tendered I'm guessing, for the record, as prima facie evidence of, I'm not sure what, that I guess the trial court made an error in not allowing testimony on the Rule 606. So you can see my concerns. These were not people who came to the defense and said, I want to do an affidavit and I want to testify and here's the error and I think this, that, and the other thing. These are people who were bamboozled into making statements to an investigator under a pretext of, oh, the Travis McMichael and Greg McMichael attorneys just want to get better, and then took all of what they said and are trying to turn it into an impeachment of this verdict. Despite Mr. Donaldson claiming that it's not an impeachment of this verdict, that's exactly what it is. And they really do not contain anything that rises to the level, and I will agree with the court on Juror 380, that does need to be explored. So the state's not disagreeing with any of the rulings that the court has, but the state is concerned with what the purpose behind these transcripts being tendered into the record are, because of course, you know, yeah, the problem really here is it's not a legally sufficient substitute for witness testimony. And an affidavit in this day and age is not allowed. The code that would allow an affidavit didn't survive our evidence code in 2013. So the problem is these aren't even affidavits. Even if they were signed affidavits by jurors who were attempting to go ahead and say something bad happened, they're legally insufficient for their testimony. So,
Okay.
Thank you.
If I might clarify, is it time for me?
Yeah. Get on with this.
Of course, hearsay is an out-of-court declaration by someone who's other than the declarant for purposes of proving the truth of the matter therein. That's a rough, I can look at Rule 901, but I think that's close to a quote. We are not attempting to prove that these transcripts are truthful. That's going to be up to the individual jurors. We're simply setting a basis, having something to say, not that they told me the truth, that is the investigator, but to say this is what was said. You know, just that. And that has to do, and then we call the jurors, and I'll ask them about, we've given each one of them a transcript and offered, and with one we've provided something that he could listen to it to compare it himself. We just want to get this in the record. And I don't want to run afoul of a court's ruling, but we're not offering it to prove the truth of the substance of the transcripts. We're offering it just to prove that that's what these people said, and that which is not hearsay. And then we'll bring the jurors in and ask them a few questions. And so the court's earlier rulings raised question in my mind as to where I'm going to be allowed to go.
Well, let me clarify then. Yeah, the witnesses are available. Based on what I understand from the notice of intent and everything that's been described here, the court's ruled. I've explained what the limitations of any testimony will be from those witnesses. They are available, and you can call those witnesses. We're not going to be dealing with the record and hearsay and everything else. The court's position, again, is they will be permitted to testify to any matters that fall within the court's ruling.
Right. I'm going to offer the transcripts themselves, and I understand the court's not going to accept it in the evidence, but I do want to make it part of the record. I do also, excuse me, and we're not offering it as hearsay, and we're not offering it to impeach the verdict. I don't know if these people would have changed their verdict. This was just simply a routine. A lot of lawyers do it. I don't necessarily do it, and I wasn't representing Mr. McMichael at the time. But it's kind of routine for lawyers, many lawyers, after a jury trial to go interview the jurors to find out what was good or bad. And that's essentially why Mr. Wilson went to see these people. And it was not, Ms. Bonikowski says, bamboozled. It was just to go find out. And if you read the transcript, you'll find that he didn't get into what was in discussions in the jury room. But he does put there are some things that pertain to external influences, such as some jurors looked out the window of the jury room and observed paramilitary people in paramilitary garb with automatic style weapons. And that we would submit is a potential external influence. If a juror is looking out and there are people in a demonstration carrying an AR-15.
Judge, at this point, I apologize for interrupting Mr. Donaldson. I have to object. I have read these transcripts. Lee Wilson asked these jurors, did you see anybody out there with a gun? Nobody said paramilitary style. Nobody said AR-15. Nobody said any of that. And I'm concerned that now it's being completely misconstrued as to what's actually in these transcripts. And my other concern is if this is for impeachment of the jurors when they testify under 613, I get that, but then use it as impeachment. Don't try and tender it into evidence and then put the juror up. I mean, we're kind of getting the cart before the horse there if it's 613 we're talking about. So the state's position is let's just put the jurors up, Your Honor.
This has now been discussed for an extended period of time. I've indicated the witnesses that you wish to call who are available can be called under the limitations that I have already that I outlined this morning. I've made as specific a ruling as I can on 3 issues.
I still will proffer, excuse me, my legs are very weak and I'm a little bit unsteady right now. We still will proffer, we'll ask the court to take these transcripts into the record. They may be totally inadmissible, in which event the court will make its ruling, but we still want them in the record as being not considered. We're not dealing with the jury here. We're dealing with what this court should and should not consider in ruling on the motion for new trial. So my plan is to put Mr. Wilson up and have him just it's a proffer. And
So you want to make a proffer of a bunch of transcripts
yes, Your Honor.
Uncertified that are in an affidavit?
No, they're not in an affidavit.
I was just trying to see if I could help. I'm not sure Mr. Possible wants to proffer these for the issues the judge said that you cannot get, Your Honor said you cannot get into, as opposed to the other matters. So you can question the jurors on that. Is that correct, Mr. Thompson? You just want to get in these other matters to the matters for which Judge Womley said you could not pursue the jurors?
I've been in this quandary since May about, I'm sorry, I should address the court, since May about having jurors and the anonymity and the privacy that the court was affording to the juror.
And let me be clear, that's going to be addressed, and I'm going to direct this to the media and the parties. If we get to the point where we are calling a juror, there shall be no cameras on the juror while they are testifying or while they're in the courtroom in any way. And they will be referred to by their number. The record is very clear on how those numbers can be connected to individuals. I assume everyone will know how to do that. But so there'll be no print or video images of the jurors, and again, we will not be using their names.
Now that's exactly what I was soliciting in the way of an order, because I know these people sat through a high-profile and emotional trial and don't need to be exposed to these problems. And Juror 580 has been subpoenaed, and she was here earlier, and she said, my understanding is she has announced that she will not come back. And when I talked to her on the telephone yesterday, she said, well, you'll just have to arrest me. And I said, ma'am, I won't be the one arresting you, but if you, and she may come. We've got her on we've told her 30 minutes notice, and she's being called right now. So that's just the announcement. Now, 380 and 79 are here. So, and that's the whole reason I wanted to get some clarity as to where we are.
Mr. Johnson, I've said a number of times, the court is not here to tell you how to do your case. So let's move into the evidence. If you have witnesses you wish to call or anything else with respect to your motion for new trial,
we'll call Lee Wilson.
Lee Wilson?
This is anticipated. Mr. Wilson,
Well, he's called as a witness. Let's let him get into it. Good afternoon, sir.
And remain standing, face that way, raise your right hand.
So I tell the truth, whole truth, nothing but the truth?
Yes.
Better see.
Your Honor, I want to make one additional announcement here. I will not ask any questions about where he can be located. Some of the people involved in the trial of this case received death threats, and I just assume he not, we can give the court the information, his business address and all of that, but I'd rather not put it on the record.
And also, since we just had this conversation, I just want to be clear, the witness was not in the courtroom at the time, and I understand that some of this testimony may address jurors. The jurors are not to be identified by name, only by number.
Yes.
Your witness.
If you would just introduce yourself to the court.
Yes, my name is Lee Wilson. That's Leewilson.
And what kind of business are you engaged in?
I own and operate a private investigative business.
And how long have you been in that business, that type of work?
Approximately 12 years.
Were you involved in this case, the trial involving the death of Ahmaud Arbery, as in terms of the trial and in terms of preparation for the trial?
I was.
And who retained you in that fashion?
I was retained by the counsel for Travis and Greg McMichael.
And did you in fact investigate?
I did.
Were you here at any time during the trial?
Just about every minute of it. I would step out occasionally, but.
After the trial, did you have any contact with jurors who had been deliberating and returned a verdict in the case?
I did.
Can you tell us the purpose of contacting? Well, first of all, did you get to contact all 12 jurors?
I got to contact probably 10. I don't have the statistics, but I did not speak to every one of them.
You did speak to how many?
I believe it was 10 that I actually made contact with.
And of those 10, were they cooperative in terms of, were they all cooperative in terms of talking to you?
No.
Of the 10, were you able to have an interview with some of the jurors?
I did.
And by number, can you tell us who those jurors were?
I can. Juror number 79, juror number 380, and juror number 580.
And have you seen those 3 jurors today?
Yes, I have.
They've been here in the courthouse?
Yes, they have.
And are you aware of any contact that we said that we put them on 30 minutes call, is that correct?
Yes, and I believe 2 have returned.
2 have returned. And you had one juror who did you have a juror who's not cooperative or says she's not cooperative in terms of returning?
I did.
All right, and which juror is that?
That would be juror number 380.
380?
580, excuse me.
580. All right. You interviewed 3 jurors following the trial. Is that a normal practice for you?
I've done it a number of times over the years. Not every attorney wants it or needs it. It depends on the verdict and whether it goes, which way it goes. But it's not an uncommon practice. I've probably done it 20 times in my career.
What's your purpose in general, and I know in making or contacting the jurors and interviewing them? What purpose?
The purpose is generally to determine what we could have done different, better, try to learn from the experience and try to make the attorneys, and even if it helps me in my investigation, learn more on what we maybe should have done or could have done.
Are you there to be critical in any fashion of the jurors?
Not at all.
Are you there to try to get the jurors to reconsider their votes?
No, no. In fact, I tell them they do not have to cooperate. It's optional.
With respect to the 3 that did speak with you, did you record them?
I did.
And did you tell them that you were recording them?
No.
Is that common in your practice, to record and not disclose that they're being recorded?
Much like law enforcement, yes, I do that. I do it daily, as a matter of fact, on witnesses I interview.
Now, have you listened to the audio tapes or audio of those 3 interviews?
Yes.
Do you know whether transcripts were produced with respect to those 3 interviews?
They were.
Have you, may I approach the witness, Your Honor?
Yes.
I'm going to mark these as Defendant's Exhibit 1. Defendant's Exhibit 2, Defendant's Exhibit 3, and I'll display them to counsel. I'm sorry, I'm kind of pretty late today. Thank you. May I approach the witness?
Yes.
Mr. Wilson, I'll hand you 3 envelopes with some contents and ask you if you're familiar with the envelopes and the enclosures.
You just go through them one by one?
Yes.
Okay. The first one is a white manila envelope marked Defendant's Exhibit 1. Contained inside is a copy of the transcript of my interview with Juror 79 conducted on July 9th, 2022.
Now, have you compared that transcript with the audio of the interview?
I have.
And can you tell us, there are some places in it where it'll say inaudible and things of that nature, but other than those places where that occurs, and it occurs all the time in transcript, other than those, how does it compare in terms of accuracy relative to the actual audio?
It's exactly what each one of us said during it. It's a fair and accurate depiction of what was said during our.
Have you listened to and personally compared those the transcripts to the audios?
I have.
With respect to Exhibit 1, that's Juror 79. Is that correct?
That's
I
correct.
don't need to pull it out.
That's correct.
All right. Is that transcript accurate in terms of the content of the audio?
Yes.
All right. Now, could you go to Exhibit 2?
Exhibit 2 is a white manila envelope containing a transcript of a interview that I conducted with Juror 380 on June 25th, 2022.
Have you had occasion to have conversation with Juror 380 recently?
Last week.
And if you place it in, I'll ask the same questions in terms of identifying it. Have you listened to the audio tape of, I don't know whether it's a tape, have you listened to the audio of the interview of Juror 380?
Yes, sir.
And how does it compare to the content of the transcript?
It's a fair and accurate depiction of the conversation I had with Juror 380.
Right. And if you'll go to exhibit number 3.
A white manila envelope marked Defendant's Exhibit 3 containing a transcript of an interview with Juror 580 that I conducted also on June 25th of 2022.
And the same questions. Have you compared that transcript to the audio of the interview?
I did.
And how does it compare?
It's a fair and accurate depiction of the conversation I had with Juror 580 on that day.
And one more authenticating question. With respect to each of those, can you tell us whether the audios, the tapes, whatever it was, a tape or some, I don't know what the right word is, the audios, do you know how they compare to the actual interview that you had with those 3 jurors?
All interviews were digitally recorded and then uploaded to my company's server where they were marked and identified and saved in a client vault. I have a database that I use for client-sensitive information. And I've downloaded those interviews and compared them with the transcripts in preparation of this hearing.
Donna, we'll tender or proffer exhibits 1, 2, and 3 for the record. Defendants' exhibits 1, 2, and 3 for the record.
Well, the state's going to object. Number 1, their hearsay, and number 2, the relevance. And I understand that Mr. Donaldson said he's proffering them.
Well, I understand the objection is relevance and hearsay.
Yes,
that's
Judge.
sustained.
It is sustained.
Sustained.
All right. We proffer them to just be included in the record. I understand the court's not going to consider them, but in this case, and I assume, and I don't mean any disrespect to the court, but motions like this don't get...
I'm not going to allow the tender of them right now to the record. I'll take it under advisement, and I'll consider it. I understand that's a request to make it part of the record, or make them part of the record.
Yes,
and Mr. Donaldson, let me finish.
Under seal.
Well, I haven't sealed them. The problem is they're not under seal. And the moment they come into the record is they become a public record. You are dancing on the head of a pin under Rule 606 here. And I am concerned on a number of levels about what is trying to be accomplished by tendering these in just simply to the record. They are not relevant, and they are hearsay, so they are not evidence in this court. So at this point, I will take that request under advisement, and we can move on.
Thank you, Your Honor. And with respect to the hearsay objection, we are not offering them to prove the truth of the matter of the statements of the jurors. We're offering them so that it's not hearsay. It's only hearsay if we're trying to prove that what these jurors said is truthful. We're offering them just to have the evidence to say that this is what they said, prior statements, and that's the purpose of it. The relevance, of course, is left to the court's discretion.
Court's ruled.
All right, understand. Your Honor, in terms of the proffer, that's what I offer. That's all I wanted to offer, is just to get them in the record. Mr. Lamar, at a later point, will examine Mr. Wilson concerning other matters not related to these transcripts. So I'll pass the witness to Ms. Donikowski on that, and we will probably recall Mr. Wilson to testify to other matters, not hearsay, but relevant and having to do with his observation.
Why aren't we completing the witness?
Pardon?
Why aren't we completing the witness?
Well, I can certainly do that.
He's on the stand. He's under oath.
All right, well, I'll do that. I do want to get the issue of proffer in terms of the transcript, in terms of the record. I do want to put it together, so if I could pass to Ms. Donikowski on that issue, and then I'll address the others.
I may be mistaken, but I understand the state simply objected, and that has been sustained. So I don't believe there's no, unless I'm wrong, and I don't think I'm misunderstanding where we are procedurally, the state's already put its position on the record and the court's ruled.
Yeah, I understand, but I thought perhaps she would want to cross-examine.
We've gone over this a number of times.
All right, and I'll do the remainder of the examination. Let me get those exhibits. For a moment, I need to display these exhibits to the state before I try to examine them.
Okay.
Yeah, that's not up a little bit. We're just going to establish the atmosphere of trial. One of those forms a packet for you. Just in front of you, go ahead and I'll number them in sequence. Top one will be 4, and then 5, 6, etc. Thank you. I'm sorry I'm a little bit feeble, Your Honor, and not moving well, but
We could just assist him with getting documents up to the witness.
yeah, I'm just going to put the numbers in the court. For the court, I'll hand courtesy copies of these documents to the court, and I should note in sequence I'll number them starting with number 4, and I'll do that here, and the court will note what I'm looking at. I've given the same to Ms. Donikowski. If I could sit down and number them.
Yeah, in fact, you can feel free to take a seat, and if that microphone reaches down, and however you need to do it, sir.
Yes, Sean, I'm not asking for sympathy. Yes, I should have pre-marked them, and I apologize, Your Honor, for not doing so. Need some more stickers. Thank you so much. Didn't realize what's going on. Just for consistency, I will display the number. Could you get this Stonekowski, and just so that she can be sure that we've numbered them in sequence. I don't know how to sit and examine. I have to stand. That's what I've always done. We'll make sure. There's some of those I'm sure, or maybe all of them you get to. That one is just to illustrate, to take illustration. That's all we could do. I'm not trying to pick on If you could, before I ask you questions about them, I'm sending to you some photographs, and we'll talk about them in a moment. You testified that you were here almost every day of the trial. Is that correct?
Yes, sir.
Can you tell us a little bit about outside this courthouse? Not inside, but outside the courthouse, what you observed in terms of goings-on.
Objection. Relevance, and there's absolutely no enumeration of error pertaining to what was going on outside the courthouse.
May it please the court, my response is that we believe that the jurors, or some of the jurors, were exposed through the window to what was going on outside the courthouse. And there is, in the transcript, there is some reference to that as an external influence. They are looking out, seeing armed people. And again, it's not juror misconduct, but it's external contact. And I just simply wanted to illustrate the atmosphere around the courthouse.
Well, Mr. Chappell's already touched on this already. The transcript is full of references to exactly what was happening around the courthouse in real time, primarily thanks to Mr. Goff during the trial of this case. After lunch, at least for the first couple days of trial, and then from there. And then also, at least with respect to the jury, as you have mentioned, it is referenced in the trial transcript. And in fact, the court announced to the parties during the trial that I was moving the jury. So that's all in the transcript. So as far as what his observations were, yeah, you were going to need to get more than that. So that's sustained.
If I might respond, these are just graphic representations of things that are in the record. And yes, the court did move the jury for the announced reason that you couldn't make out what they were saying, but they were hearing sounds.
I sustained the objection to the question. You have some pictures. Now, if they have some relevance, then you can go ahead and get into that. But again, that question, the objection is sustained.
Have you looked at the photographs that have been handed to you?
I have.
Take the last one out because it's a little bit different and unrelated to the specific line of inquiry. Can you tell us the numbers on the exhibits that you are looking at?
Let me get it back in order. Exhibit number 5 is...
I don't want you to describe them because we'll talk about that in a minute. Just what are the numbers on the exhibit?
Exhibit 5, exhibit number 6, 7, that one's 4, 10, 11, 12, 13, 14, 15, 16, and 17, and 18.
Now, and again, we don't need to get deep into each one. Can you just generically describe what those exhibits, 4 through 18, what they display?
In general, they display activities taking place on the perimeter of the courthouse, primarily during the last 3 days of the trial, which including the closing arguments, the jury charge, and the deliberations.
And have you made observations yourself as to what was going on outside the courthouse?
I did.
Just tell us in general what you saw.
Objection. Relevance.
Yeah, no, I understand and anticipated that. I just had the same response. And again, we believe, and the court's indicated that it's replete in the record. And I suppose, repetition or something of that nature, but we believe that what went on outside the courthouse is relevant because jurors were exposed to it. Now, I understand, I know I'm a little bit cart before the horse, and that really is the purpose, is to, when these jurors testify, I will ask them questions not about these photographs, but what they saw, in fact, Mr. Lamar will be doing the direct examination on that, but that's the purpose of all of this. It's to lay, I don't want to say a foundation, it's to lay the groundwork for the examination of the jurors, and that's the purpose. We tender them. They understand the objection, and I suspect the court will sustain it.
And I'm going to sustain it. I'm not suggesting that the argument's not there. I've told the parties that if extraneous information was there, then the court needs to know about it. But the record is replete with what was going on around the courthouse, and I have not heard anything specifically about what may have been extraneous to the panel, and so it's sustained.
They're tendered,
and the objection was sustained.
Yes, sir. If you would look at exhibit number 19, can you tell us what that is? what that is telling?
Yes, Exhibit 19 is a picture from the interior of the courtroom, much from where I'm in the area where I'm sitting now, shooting backwards.
You know why that? You know the relevance of that photograph with regard to the issues that are before the court?
I do.
Can you explain that to the court?
The state's table during the trial had been turned. We'd set up the courtroom the Friday before jury selection, where it's much like it is today. And when we
Objection, once again, relevance.
Yeah. Again, it is sustained.
Please, court, one of the issues in the motion for a new trial, the amended motion for a new trial, is the connection between the prosecution and the jury. And we offer Exhibit 19 solely to illustrate where the table was, the prosecution table, in relation to the jury. And we believe that's relevant for that purpose, and I tender it for that purpose.
Your Honor, I'm confused, but I will try and clarify. It appears that in enumeration of error number 6 of Travis and Greg McMichael's amended motion for new trial, they claim that one of the jurors could read my mind and my facial expressions, and that therefore there was prejudicial communication, not intentional by me, which I appreciate, but that unintentionally, because my facial expressions were seen by the jurors, that I somehow demeaned the defense attorneys during trial, and that this is for error. And I didn't have you mention, I noticed you didn't mention that as one of the grounds for the jurors to be covering. So I didn't know if you were anticipating having testimony as to that juror and her thoughts about my facial expressions, because that goes into the thoughts and minds of the juror, and it is outside of Rule 606, because defense counsel is not alleging I was doing it on purpose to communicate extraneous prejudicial information. Number one, it wasn't extraneous. I was in the courtroom. And number two, everyone could see it. This photo, number 17, the state and the court all understand that we had 4 alternate jurors. And 3 of those alternate jurors were seated behind the state's table. And the reason for that is because we had all the jurors in the box, and 3 of them sat behind. There's a partition so that the audience members and the jurors were separated. And of course, the defense didn't want the jurors, and no one wanted the jurors, to be able to see what was on the state's table. I understand that Mr. Donaldson wants to put this picture in just to, I guess, bolster the fact that our table was on an angle, but I'm pretty sure everybody knows that.
Well, let's do this. I misunderstood which photograph we're talking about. So, yeah, I'm going to permit that. I mean, that's admitted.
It's just illustrative of the point. I want to address what may be a problem. Had you had contact today with Juror 580?
I did by phone just a few minutes ago.
What had she indicated when she was here and left earlier?
She was
I'm
not
going to object to hearsay.
What she said,
I don't know whether she'll be here or not.
well, if she's under subpoena and she does not appear when called, then she's not here. What she said to the investigator is that's hearsay.
Let me check with Mr. Lamar. That may be all I have for this witness. Mr. Lamar was going to examine, our plan was to examine Mr. Goff, again concerning the atmosphere and the goings-on around the courthouse. I understand that the court has essentially taken notice of it and that anything would be cumulative and not particularly, doesn't add anything to where we are. And if I understand the court's ruling, there wouldn't be no necessity to call Mr. Goff back to the witness stand. I just want to make sure that the court has established for the record that there were various things going on, that there was a crowd, that it was an atmosphere of people outside demonstrating and protesting. And if that's in the record, and I submit that it is, but I want to make sure that the court is acknowledging that. And if that's the case, we won't call Mr. Goff.
Sure, I find it very dangerous to say, yes, I acknowledge that. What I will say again is the record is replete with references to what was going on around the courthouse. The issue is, to me, the question is not whether or not there was or was not something going on around the courthouse. The question I think you're trying to get to is whether or not the jury was exposed to extraneous information.
Absolutely. That's what we're trying to do and establish that.
Those are two completely different things. So again, I have said over and over again, Mr. Chappell first said, I recognize the record has all of those references in there. Mr. Goff, I think, put a great deal of effort during the trial into making sure that it was very clear to everybody that this was not a trial that was going on in a vacuum outside.
Understand, the court has, I assume, in the record, because they were sealed, at one point Mr. Goff made a motion regarding, he made the motion many times, but toward the very end of the case, he took photographs from the balcony outside of the crowd, and he tendered them in connection with his motion, and they were tendered under seal. And I would ask that those photographs, as he described them, be considered part of the record for this hearing.
I have no memory or recollection of that. And
I can find it in the transcript.
I would have to wait for a response from the state and hear from the other parties. I'm not sure what we're doing, because again, what the court would be very open to at this point is evidence, if there is any evidence, of the jurors' exposure to extraneous information, if it even occurred, because that's the threshold question.
State agrees, and we haven't gotten to the threshold question yet. So,
I understand that I have approached this backwards, and the reason for that is to rather than have the juror testify and then bring the photographs and things of that nature, I wanted to establish what was out there. It may or may not be relevant based on what the jurors testified to, and that's the purpose of it. I apologize to the court if I've done it in reverse, but it just seemed the more logical way to approach it. And I think I'll pass the witness at this point.
Any questions for the witness from the state?
yes, Judge. All right, Mr. Wilson, taking a look at defendant's exhibit number 19.
Is that the one with you in it?
Correct. We're looking at defense exhibit number 19. And this is a screenshot from 11 Alive News, is that right?
Yes, ma'am.
Okay. And it's of this courtroom?
It appears to, yes. Yep.
And is that Jason Sheffield standing at the podium that I'm standing at right now?
It is.
And does it depict the screen that was put up between the pews where the audience could sit in order to separate the Arbery family and the McMichael family and the press from 3 of our jurors who were seated directly behind the state's table.
Yes.
And those 3 jurors sat behind the state's table, spread out, because it was in the time of COVID, when people were still masked up, and the table was moved on an angle by agreement with all parties so that the jurors would not be able to see the state's computers or the state's documents. Is that correct?
It was moved. I'm not familiar with an agreement, and I've spoken.
Well, don't go into anything anyone said, because we don't want to go into hearsay.
I'm unaware of any agreement.
So you're unaware that Travis McMichael's trial team and Greg McMichael's trial team and Mr. Goff all knew and wanted this table on an angle that the state was at so that the jurors would not be able to see anything at the state's table, because that would be a problem then. You're unaware of that?
I'm unaware of that.
But you are actually very aware of the seating arrangements within this courtroom and the partition that separated the jurors from the other people who are watching.
Yes, because I sat on the second level. I couldn't see their computers, but.
So you were seated primarily on the second row because, as we have today, we have sheriff's deputies who are seated on the first row. Is that correct?
That's correct.
I'll pass the witness.
Any redirect? No further questions, Your Honor.
Thank you, sir. You may step down.
Yes, sir.
We will call juror 380.
And, Your Honor, we are going to ask that the rule of sequestration still be imposed if, for some reason, I'm assuming juror 380 says something different than what's in whatever these alleged transcripts say. They're going to want to put Mr. Wilson back up.
For impeachment purposes?
Yes.
Yeah, the rule's still in vogue then.
Thank you, Judge.
Juror 380. I'll turn up.
Yeah, we can do audio. That's fine, but the camera's off. Or you can, that's fine. Do I tell the truth, whole truth, and nothing but the truth?
Yes.
Go ahead, have a seat, sir.
Good afternoon, sir. Let me begin by asking you, were you one of the jurors? And I will not use your name. I will not use your name, but I will use your number. Were you one of the jurors in the trial of the involving the death of Ahmaud Arbery?
Yes, sir.
And you were juror 380, 380?
That's correct.
You and I have met before?
Yes.
And that was, what, about a week ago?
About a week ago.
And you were subpoenaed, and with your subpoena package, you received a copy of a transcript of an interview. Did you recall that?
Yes.
And did you read that transcript?
Yes.
We spoke after you read the transcript, and you said you wanted to compare it audio an audio, is that correct?
Yes.
To see if it was accurate.
I didn't listen to the audio. Didn't have nothing to play it with.
You didn't have anything to play with. You told us that you would need a CD, a compact disc, and we delivered to you what we believed was a compact disc. You recall receiving that?
She delivered a DVD.
All right. So you were not able to compare the transcript to the audio because you didn't have anything to play it on.
No.
All right. So we'll work without that. Excuse me, let me get 3/8. Let me step over here. Thank you so much. You're a very deeply religious man, are you not?
Yes, sir.
And you pray daily?
Yes, I do.
And you've described that you pray daily to me.
Yes.
When Mr. Wilson and I came to visit you, I guess it's a little over a week ago. Is that right?
That's right.
And we sat on the porch and talked, and it was a pleasant conversation.
Yes, sir.
And you talked to me later on the telephone, telling me that the transcript seemed to be scrunched up in terms of, I think you said scrunched up in terms of what was said, and I understood that to mean
right.
that
Some of the things that I explained, he cut it off and went to something else.
Okay. And that's based on your memory?
No, that was in the script.
Okay, it's in the script. Do you recall being asked by Mr., and this was back in June of 2022. Now, it was about
Form of question. First off, this witness has not testified to anything, so refreshing his recollection with his prior statement is inappropriate, and the state would object.
I'm simply trying to establish a time frame for the interview. That's, I don't know.
I'll let you then let's ask him about the interview.
The interview, the transcript says the interview took place June 25, 2022. Is that consistent with your memory?
I believe so, yeah.
You were asked about your feelings about being on the jury, that when you got picked. Is that right?
Right.
And what were your feelings?
Well, I feel all right.
Objection. Relevance. Outside the scope of 606.
Actually, Your Honor, we're not dealing with 606. We're dealing with actions. I don't want to say too much in front of the juror, but we're dealing with things that he did and what his attitude and feelings were about being on the jury, as reflected in the transcript.
But you're referring to the most recent transcript, not questions asked during voir dire, correct?
That's correct.
Okay, then that's sustained.
Well, you sustained the objection.
I did.
All right. What was your feeling about the family before you were picked to be on the jury?
Well, I felt sorry about what had happened.
Right. And I'm trying to get around the rules concerning examination. And I know I'm going to try not to lead. Can you tell us just generally what was wrong with the transcript? Tell me what in the transcript was not accurate.
Objection. Relevance.
Sustained.
All right. you at some point realized that you were the only African American on the jury.
That's right.
Objection to this line of questioning. This has absolutely nothing to do with the purported issue of lying during voir dire. So I apologize, but I'm going to keep objecting until we get to some relevant evidence.
Is that sustained or?
Well, that standing alone is sustained.
All right. Well, I didn't get all the way through the question. You remember when you came and were first on when they were picking the jury? Do you remember being at this courthouse?
Yes, I remember.
And do you remember being asked the question whether you had any prejudice or bias on your mind regarding either of the parties? And let me get the right question. You remember that they called you and asked you questions all by yourself?
Yes.
And that was after you had been asked questions, the whole panel were asked questions. You remember that?
Yes.
All right. Do you remember raising your hand and agreeing to tell the truth as you, even before you were questioned individually?
Yes.
And you remember that you, as the panel, all of you at one time were asked whether your minds were perfectly clear and that whether you had any prejudice or bias resting on your mind about the parties, about the case.
Objection.
Yes.
That's a misquotation of the question asked to the juror.
All right, let me get the right question. If I could have a moment, Your Honor. I'll need to sit for a moment and look for it. Get my notebook. Thank you, I appreciate it. John, I'll need a moment. Thank you. Thanks. I think I can make this. The statutory question is in Official Code of Georgia, annotated, section 1512-132. And the question is, you remember they asked everyone all at one time, you all were sitting in a panel, and you were asked whether you had any prejudice or bias for or against either the defense or the prosecution. You remember being asked that question?
Objection.
Do you remember being asked that question?
If there's an objection,
I'm objecting because that is not the question that was specifically asked at page 200 of volume.
If I could defer to Ms. Donikowski, if she could read the question at page 200 of volume, I think that's probably
Not a
one
problem,
or
Your
two.
Honor. I will read the question.
Great.
The question was asked, have you any prejudice or bias resting on your mind either for or against the accused? And that was the same question asked every single day. Thank you.
Do you remember that when you were sitting with other jurors, that question being asked?
Yes.
And it was one of those situations where if you had prejudice or bias, you were supposed to raise your hand or let the court know. Is that right?
Right.
And you didn't say anything to the court about having any prejudice or bias about the accused.
No.
And do you recall when Mr. Wilson came and interviewed you, you told him that the Lord said that he would guide you. Is that right?
That's right.
And you told him that if the Lord
I'm going to
was...
object. Once again, he has not asked this witness a question in order to impeach him with a prior statement to Mr. Wilson. And I'm just asking for it to be done correctly, for a question to be asked of this juror.
I don't really know how to respond to that, Your Honor. I'll try again. Did you, in your mind, when you were potentially being picked as a juror, you asked the Lord for his assistance?
Yes.
Right? And the Lord told you that he would guide you. Is that correct?
That's right.
And at one point you said to the Lord, and this is before you were picked, but after you had been summoned.
Objection leading.
Oh, my God.
It's a leading question. I mean, I apologize, Judge, but at this point, he's asking a yes or no question. Did you say all these things?
I will withdraw the question and rephrase it.
Thank you.
What did you say to the Lord?
I asked him that I would go, he lead me and guide me through the whole thing, and he did.
Did you have any feelings about the family? And I've asked you that question, but tell me again.
I felt sorry for the family, and after the court started, I felt sorry for both sides.
All right. When did you tell Mr. Wilson anything about whether you would... Well, tell me what your feelings were about helping the family.
I wanted to help for the truth to come out, to know right from wrong.
Let me get the transcript.
And I learned during my years that right is right and wrong is wrong. No matter how you twist it or turn it, wrong is still wrong.
I understand. You know, I'm having to kind of dance around to get to the things that you and Mr. Wilson talked about. Where were you working? You worked for the railroad?
Yes, sir.
And at the time of this trial, you were working in Alabama.
Alabama, yeah.
And,
Anderson.
what was your job with the railroad?
I run a machine.
If you could describe the jury that while I look for the right page in the transcript.
This machine's when they pull the spike out that hold the rails down and take the rail out, this machine shoot a chemical in each spot where the spike came from, and within a second after that chemical mix in there, it get hard. So when they nail the track back, it is solid. It is 57.5 inches from one rail to the other. And just like you do in a hinge and a door, that would just do it. It plugs the hole where when they put the rail back in, it hold the rails in place.
Your Honor, obviously I've lost the page I'm looking for, and I don't want to belabor it, but I do need to look for it. And what I've done is I've brought the copy of the motion that does not have my notes in the margin, and so I have to look for it. All right. Did you say anything to the Lord about whether you should help the family?
Well, I was already summoned, and I wanted to do the right thing.
Did you say anything about you wanted to help the Arbery family?
Yes, I wanted to bring out the truth. If it did happen, I wanted to bring the truth out.
I understand. When you talked with, and on the record, when you talked with Mr. Wilson, did you say to him, to the Lord, I feel sorry for the family. You want me to help them, then I don't mind doing it. And that was a reference to the Arbery family. Is that right?
Both families, I wanted to bring out the truth.
All right. And when Mr. Wilson asked you, but when you say you felt sorry for the family, did someone talk to you about sitting on the jury? And you said, no, nobody's talked to me about this. Is that right?
No.
And then Mr. Wilson asked you, I didn't quite understand when what you mean felt sorry for the family. And you told him, I felt sorry for the family and everything. That was even before I see the tape, the film and everything. So I talked with the Lord on my way, going to work, and this was before you were actually picked, but after you were summoned. I said, if it's for me to do, then I'll do it to help the family because justice got to be done. Do you remember that?
Yes, I remember that. I have 4 sons, and when something like this happened, if you got a son, then it sort of hit home.
Yes, I've got 2.
So nobody wants that to happen to their family.
And in part of the interview, did you tell Mr. Wilson, the Lord showed me? He set everything up. Anyway, after I prayed, I cried for the family, and it turned to a joy cry, and I didn't even know I was picked yet.
That's right.
And in your approach to this, and when you were when you were questioned as a juror, and I'm not talking about when you were brought in and asked individually, but when they asked the question if you had any prejudice or bias resting on your mind, and you didn't raise your hand, you had already said you wanted to help the Arbery family because justice needed to be done.
I wanted to help all the families. I cried because of the situation that was happening. And back in the old days, the same thing happened. And the fact that the same thing happened today is going on.
So have you talked with anybody besides me and Mr. Wilson concerning your testimony today? When you read the transcript, and I know you said there were some places crunched together, when you read the transcript, was it accurate when it described your conversation, when it recited your conversation about your feelings before you were put on the jury?
Not quite.
Where is it not accurate?
Well, after I seen the film and everything, when I seen the whole deal, what happened, and that night when I got picked, they asked me if I could make a clear judgment, and I told them, I said, yes. I said, but I got to see. I said, I don't understand what went on, but once I see what happened, then I could judge from there.
Okay.
And
that's a little bit different than what you told Mr. Wilson, isn't it?
Mr. Wilson came and wanted to talk, but he didn't tell me he was recording anything. I talked with him for a few minutes, and that was it.
You recall, you live pretty close to here, don't you?
Yes, sir.
How far from here?
Just about 2 blocks.
And if you stand in the street in front of your house, you can see the courthouse. Is that correct?
That's right.
And you can just walk down here in 5 minutes.
Yes.
And during the course of the trial, you could hear what was coming when you were at home. You could hear what was going on around the courthouse.
Not at my house, I didn't.
All right. Well, one day during the weekend, did you come to the courthouse while they were having the demonstrations?
One day I was riding down Norwood Street, and I was going to go get something to eat, and they had a thing set up there. They were selling, I guess, hot dogs and stuff like that. So I stopped and got a hot dog.
And you got a hot dog where they'd set up some booths or had food trucks, or what
they
was
just
it?
had a big grill.
Had a big grill. And were they just people grilling?
Yes, and people standing around.
All right. And you understood that when you went to get a hot dog, the reason they were there was rally.
Objection leading.
Sustained.
Tell us whether or not, was there a crowd around the courthouse?
Yes, pretty well.
A pretty good crowd. And it was on a weekend?
I think it was.
Now, on a weekend during the trial?
I think that was just before the trial got started. About a week or so before they got started.
All right. And, did you tell Mr. Wilson it was during the trial?
He didn't ask.
No, the question is, did you tell him it was during the trial?
I don't remember. I just told him.
And you knew after you were summoned to be on the jury, even before you came down here, but you'd been summoned, you knew you didn't need to be involved in conversations about the trial.
I didn't talk to nobody about the trial. I bought a hot dog.
You shouldn't.
Objection.
I didn't know. I did not know.
I just would like Mr. Donaldson to please not talk over the juror while he's answering the question.
It's improper for me, and I apologize.
Just let the witness finish his answers.
Once you were summoned to be on the jury, even before you came down here, you knew you weren't supposed to be talking about the case because you were summoned as a juror.
When I got picked, I was working in Alabama, and I was going back and forth. So when I come home to pay bills, I'm here and there paying bills and back to the house.
Was there any kind of a rally going on when you came?
I didn't pay no attention. Just when I came up to buy the hot dog, I hear what was going on, and I went on about my business.
Yes, sir. And did you?
Anybody.
I'm sorry. Go ahead.
So I didn't talk with nobody. I just bought a hot dog and went on.
Okay. Your belief was it was okay to hear things as long as you didn't talk to people.
Well, when you walking around and paying bills, you're going to hear some of everything.
I'm sorry, explain that, please.
When you walking around and all that going on, at particular time, it was a lot of things going on. You couldn't miss it. I mean, if you could hear, you hear all kind of stuff.
And there were speakers, people making speeches at the time. Is that right?
At that time, I heard they were speaking.
And you heard the people making speeches.
Yes.
I think you described it as blah, blah, blah. Is that right?
Yes.
You didn't talk to anybody or tell anybody you were on the jury.
No.
But you heard and listened to people making speeches.
When people stand around talking, they talk. And if you could hear, you're going to hear everything. It's just like in the church when we fast. You walking around and you could smell all kind of good food. You can't close your nose off. You're going to still smell it. And the ear worked the same way.
So you could hear when you went to get the hot dog down among the demonstrators, you could hear what the people were saying.
Yes.
And they were saying things about Ahmaud Arbery.
Yes.
And it was a rally for Ahmaud Arbery.
I don't know if there was a rally or not, but whenever something like that happened, it affects everybody, and people talk.
People talk, but you were careful not to talk.
That's right.
But you heard what was being said.
Yes, sort of.
And you do remember, or do you remember, telling Mr. Wilson that you told the Lord before you were picked for the jury, you told the Lord that if he wanted you to help them, the family, you didn't mind doing it.
That's right.
And you told the Lord, I'll do it to help the family because justice got to be done.
I asked him if he'd lead me through the whole thing. So I had to find out what was going on and go from there. I didn't tell him a lot. I asked him.
I see.
You can't tell the Lord. You ask him what, and he'll work from there.
Okay. May I have a moment, Your Honor?
Yep.
I'll pass the witness, Your Honor.
Sunkowski.
Thank you, Judge.
Thanks.
Juror 380, how are you?
Doing great.
Thank you for being here. When you were asked during general voir dire on Monday, October 25th of 2021 whether you had any prejudice or bias resting upon your mind for or against the accused. Did you tell the truth when you answered that?
Yes, ma'am.
And I know this was a long time ago, and it was your kind of questioning by all the parties when we were in this room. But do you remember telling us that you had actually seen a rally at some point before the trial started?
Yes.
Okay. And do you remember, there was something about going to the hardware store. Do you remember that?
Yes, right over here.
Right over here, right. Now, was the day that you saw the rally when you went to the hardware store the same day that you went and got the hot dog?
Yes.
Okay, so that was all the same day.
Right.
Okay, so on October 25th, and I'm referring so that you guys know, I'm on the October 25th transcript, volume number 9, pages 2132. I believe you were talking with Mr. Rubin, who was Travis McMichael's attorney, and you indicated that you went to the hardware store one day and you heard a commotion.
Yes.
Okay. And you revealed to all of us that you got what you needed to get and you went back home because you knew you'd been summoned.
Right.
Okay. And you explained that that was the hardware store over on Norwich.
Yes.
And he asked you, do you know what kind of rally it was? And you indicated, no, I didn't know what kind, but they had told you that the folks were rallying over about the murder case. So you were like, I'm not even going to go over there.
That's right.
Okay. And once again, you reiterated, I just got what I came to get and went. Do you remember that?
That's right.
All right. So now, when Investigator Lee Wilson showed up at your house on June 25th, 2022, did he call you and tell you he was going to come?
No.
And in fact, when he showed up, you were on the phone with somebody else, weren't you?
That's right.
Okay. And so he didn't have an appointment,
No.
but you agreed to hang up on your phone call and speak with him.
That's right.
All right. And do you remember him telling you that the reason for the interview was that the defense teams all wanted to try and do things better?
He told me that everyone spoke highly of me and how I prayed with them before they go in the jury room. And so I said, okay, take a seat. I'll be right back.
Okay.
So I went and hung the phone up and came back.
Got it. And did he, well, I think you said he didn't tell you he was recording you, did he?
No, he didn't tell me that.
Okay. And I think at one point you may have said to him, in the context of trying to demonstrate how you weren't out there trying to get information about the trial while you were a juror.
Right.
You indicated that you rode out there one day and they had some stuff set up around the courthouse. They were selling hot dogs and stuff, so I stopped and got a hot dog. They had the speakers set up there and they were steady talking, blah, blah, blah. I just listened, got a hot dog and a drink and kept going.
That's right.
Okay, now was that the same incident date as the hardware rally?
Same date.
Same date. So that had to have happened before the trial started, because obviously you talked about it in jury selection on October 25th, right?
Right.
All right. So you had revealed to the parties about this particular incident.
That's right.
Okay. And I think Mr. Wilson then asked you something like, this was after court or on the weekend or something, and you indicated it was on the weekend.
Yes.
Okay. And then he asked you during the trial. Now, you never said yes or no. I think what you said was, the judge told us we're not supposed to be in a conversation, don't even be involved, so I kept to myself and just did what the Lord said to.
That's right.
All right, so you didn't actually tell Mr. Wilson that this happened during trial, did you?
No.
No, that was him trying to ask you that, and you didn't respond. So I'm going to ask you again about your jury questions. Do you also remember telling Mr. Rubin that you'd heard the phrase justice for Ahmaud, and that you said, it means to me if somebody was wrong for killing him, then they need to get the justice and to bring peace to the family and to the neighborhood?
That's right.
Okay. And you told Mr. Rubin that?
Yes.
Mm-hmm. And then, I think as we were wrapping up, as you were leaving, and Mr. Rubin was wrapping up his questions, he asked you if you felt any pressure about the effects of being a juror in this case and what it means to you, and you said you didn't.
No, I didn't.
All right. And I think you then said, I pray and ask the Lord to help me to make the right decision.
That's right.
And that's what you told Mr. Rubin on your way out.
Right.
Right. And I hate to ask you this question, but because of the nature, I have to. At any point in time during your voir dire on October 25th, 2021, did you lie to any of us with your answers?
No.
No. Right. And during that questioning, no one actually asked you how you felt about Ahmaud's family.